Yeah.
Well, good morning, ladies and gentlemen. And Miss Jost. I'm going to call this October 26, 2015 hearing of the Colorado Oil and Gas Conservation Commission to order. Thank you. Roll call, please, Ms. Murphy.
Commissioner Allward?
Here.
Commissioner Benton?
Here.
Commissioner Craig? Not present. Commissioner Compton?
Here.
Commissioner Hawkins?
Here.
Commissioner Holton?
Here.
Commissioner King?
Here.
Commissioner Spielman?
Here.
Commissioner Wolk?
Here.
The only one not present is Commissioner Craig.
Do we know if she may come or we don't?
We do not expect her.
Thank you. Thank you. Approval of proceedings. You have a copy of those sent to you electronically. And by the way, Ms. Murphy, I like the format.
You do?
I really like that little block you set off that tells how many times I vote no.
Well, thank you, Commissioner Compton. Kudos to David Beckstrom
Thank
and our
you. I
hearings
like that.
unit for
On
revising it.
that note, I'll move approval.
Motion to approve and a second. Those in favor indicate by saying aye.
Aye.
Those proceedings stand approved. Report from the Executive Director of the Department of the Colorado Department of Natural Resources.
Thank you, Mr. Chairman. Morning. Welcome. Look forward to a full day, but at least it's just one day, so that's good. Mr. Chairman, it's a relatively quiet time of year. The Department of Natural Resources, we're getting our legislative agenda in order and ready for the next session, getting it through the governor's office. I think it's relatively light. We're not looking at any major new legislative initiatives, but we also know that we'll end up playing defense on some stuff that comes through that we think would be harmful to the department or our state's natural resources. So we'll continue to work on that. I don't think we've met since the decision on the greater sage grouse. We received what we think is a reasonable and well justified determination that that species is not warranted. That's good news. With that came some BLM resource management plans. Those were kind of part and parcel. There's some tough medicine in those plans, some restrictions that are we need to work through with the BLM and make sure that that we're doing all that we can to protect the sage grouse, but at the same time giving us some flexibility in areas. We have things like disturbance caps that we have to figure out what they mean and how they're going to be calculated. We'll be meeting with the BLM later this week to figure out, I think it's going to be a new area. You know, we've always participated as a cooperating agency in the development of those plans. I think here we're going to be a cooperating agency in the implementation of those plans. I think our wildlife folks in particular will be lending their GIS support, determination of what is critical sage grouse habitat along the way. We think that that's a good place for us to be. We're going to need some additional resources from the BLM to help them with that. But we would much rather be in that position than have the U.S. Fish and Wildlife providing daily counsel to BLM on implementation of those plans. Finally, we are on the verge of developing and rolling out Colorado's first water plan, which we are tremendously excited about, not unsurprisingly because it's water. As we get closer to the finish line, we have folks commenting, providing good, solid comments. There's a little bit of angst because again, it's water. That's what we do in Colorado. But a culmination of a you could say it goes all the way back to Russ George's Basin Roundtable Bill House Bill 1177. The Basin Roundtables have been meeting for 10 years in preparation for ultimately this document, which will lay out a vision for Colorado, what we're going to need to do with conservation, what we're going to need to do with storage, land use planning, and some of these other issues. It won't be the end-all be-all. It will be the first very important step in what will be an ongoing implementation of that plan. And then, in 5 to 7 years, we'll be updating it because some of the assumptions we make in this plan will no doubt turn out to not be exactly accurate, and we'll need to modify those plans. So I think having this plan in place and beginning to see what the future looks like and the trade-offs that we're going to have to make as a state is critical for all of our natural resources, but one in particular, and look forward to having a big celebration on the 18th and 19th at Colorado History Museum. We're going to have an event in the evening, and 600 of our closest friends are set to show up and help us celebrate this kind of historic moment. So, Mr. Chairman, that's all I have. If there are any questions, I'd be glad to answer them.
600 water buffaloes in one room. Be interesting.
Bring your own cup. Yep, be good.
Okay, any comments or questions for Mr. Kane? Appreciate very much the department's work on the sage grouse. I know there are a lot of landowners that have worked pretty hard to make that happen, and the department did a great job. Okay, hearing none, we'll move then to a report from the director, Mr. Lepore.
Thank you very much, Mr. Chairman. Good morning, everybody. I have a number of items I'll try to move through relatively quickly. Some of you will be aware that we are in the midst of a rulemaking to implement two of the recommendations that came out of the governor's task force.
Really?
Sincerely. As you also are aware, staff went on a little tour of the state of Colorado to hold outreach meetings to meet with stakeholders and get input from a wide array of citizens and environmental groups and local governments and so forth, industry. And following all of that, we released our first set of draft rules on October 6th. We then held stakeholder meetings, 3 stakeholder meetings, October 14th, 15th, and 16th. Then we held meetings after the stakeholder meetings with interested parties. And on October 23rd, we released our second draft proposed set of rules. There is a great deal of interest in this rulemaking. In fact, we have 72 parties to the rulemaking, which, as far as I know, is a record of large proportions. I looked back to the 2012 setback rulemaking that some of you will recall, and I think we had about 40 parties there. So we've generated interest, which is exactly what we wanted to do. I'm very pleased that many of those parties are individuals. So I think we are aiming towards inclusivity, and I think that's wonderful. The rest of the schedule for the rulemaking, we have pre-hearing statements are due currently from the parties on October 28th. I will talk to some of you today. There's talk of maybe extending that deadline by a couple of days until the 30th. Usually people don't get upset when we give them more time, but we'll try to think about that. The commission hearings on the rulemaking are scheduled to begin on November 16th and 17th. Due to the large number of parties, likely those hearings will not be held in this room. We're looking at the Sheraton, where you will recall we had some of the setback stakeholder meetings. Nice big room over there. All of everything related to the rulemaking is available on our website on the homepage. If you scroll down a little bit, there's a link to the Governor's Task Force rulemaking, and you can find all of the documents that have been produced by us or submitted to us on that link. I want to take just a second to call particularly the Commissioner's attention to this document. You all have a copy of this. This is called Horizontal Well Development, Pooling, Spacing, and Unitization, a regulatory toolbox for key policy, regulatory, and statutory considerations. This is a product of the Interstate Oil and Gas Conservation Compact and the legal and regulatory affairs of that body. It's a close look at many states' horizontal development, pooling, and spacing rules and regulations. Sort of a handy reference. As you know, we routinely look at and sometimes struggle a little bit with how to pool and space for horizontal development, working from a state that never contemplated horizontal development. So that was sort of the impetus behind the creation of this document. So it's available on our website. This document is. It's available on the COGCC website. In our website, it's under the library and under technical reports. I circulated an electronic copy to all the commissioners previously.
And who was the chairman of the committee that put that report together?
Sort of a not well known someone. I don't know. It was me, Mr. Chairman. Thank you. Turning to the staff report, I'm going to have Dave Coleman talk to you about the lean process here in just a minute. The next story talks about our local government liaisons. That's a great summary of that program. I will just take the time to point out that there are 2 LGD trainings on the schedule yet for this year, one in November in Weld County and one in December here in this office. I also want to point out that the Governor's Task Force, one of the things the Governor's Task Force did was convince the legislature to allocate 12 FTE to the COGCC. We had already asked for 2, so in the 2015 legislative session, we were given 14 full-time equivalent positions to fill. I have an update for you. We have, it's a little complicated, I'll try to make it simple. We have 10 brand new staff members on COGCC, and they run the gamut from a data analyst position, a new enforcement officer position, a notice of alleged violation specialist position. We have a new subgroup in the engineering group that looks only at flow line integrity. We have a complaint specialist person whose only job is to process the complaints that we receive from the public and get those through our system, get them to the right people to process those. We have some new reclamation specialists, new environmental protection specialists, and I think that kind of at least covers the list at a high level. So 10 brand new people. We have also transferred 5 internal people into new positions, and now we have 4 vacancies. So we are somewhere in the range of about 107 full-time employees right now with 4 vacancies to fill. And most of those positions created by the task force have been filled. Back to the staff report just briefly. I read with interest our update on the Colorado Oil and Gas Information System, particularly related to electronic forms or e-forms. It's hard, I think, for people to understand how progressive COGCC is with respect to the ability to file forms and process forms electronically. So we used 41 forms. This agency has 41 different forms. 19 of those are now e-forms, and I know that's slightly less than half, but those are the 19 that get used by far the most. So things like our Form 2 and Form 2A and our Form 5s, our completion reports, all of that is available electronically. So we continue to try to chip away at those other ones. In the last month, we have released new versions of Form 7, which is our production report, Form 26, Form 31, and Form 33, which are UIC reporting forms. And we have in the queue now our Form 27, which is our environmental spill and response reporting form, along with Forms 14, 14A, and our NOAV form. So we continue that push to move into the electronic realm instead of the paper realm. And in that realm, we are much, much more efficient, both on our side and for operators and for other stakeholders. On the Form 7, I just have to say, which is our production report. So as you all know, operators report production to us. We track all that. We have all that data. That form has just become electronic. And when that form became electronic, the production staff team, led by Terry Anokwe and Enrique here, held webinar-based training that was attended by 200 employees representing 130 different operators. And they will do that again here in a few weeks. In the same sort of vein of 21st century efforts, we continue to make our data within the database available in ways that we hope are easier for the public to use. We do that by putting large data related to a particular topic on our web base for download. So currently, the public can download our GIS shapefiles, our production data, our spacing orders, our water well data, our complaints, our mechanical integrity tests, and our NOAVs. All of those are available, updated periodically. You can pull those all off of the website and have them and do them with them what you will. We are planning to have available by the end of the year our spills, releases, and remediation data, our inspections, and our enforcement orders. Quick update on statistics. Statistics are always interesting. with the price of oil being down half from what it was a year or so ago, you would expect maybe to see slowdown in activity, and we do see a slowdown in activity. Year to date on our Form 2As, oil and gas location assessments, we are down over our average for the last 3 years by about 54%. So we are running less than half on new locations compared to what we've done in the last 3 years. New well drilling applications, APDs, are down about 21%. So not quite the dramatic decrease in wells, but in some ways those locations are sort of a leading indicator, right? You can't drill a well if you don't have a location. So I assume that difference between 50 and 20% has to do with the fact that there are locations available for operators to drill on now. They are slowing down dramatically in the number of new locations. Interestingly, this is a very surprising statistic, I think, and I know from my work with the COGCC that Colorado is different. We are an outlier in this regard, and that is that our oil production, despite the slowdown now occurring in drilling, oil production for 2015 is currently running ahead of 2014 by more than 30%. So I don't know whether that can be sustained through the end of the year or not, but it's rather surprising. Horizontal wells continue to comprise about 75% of all new well starts. Again, if your memory can only stretch back 6 years, horizontal well starts comprised less than 2% of the total. So in 6 years, we've gone from 2% to 75%. Completely revolutionized the way we are producing oil and gas in Colorado. The vast majority of those wells, not surprisingly, are in Weld County. Year to date, Margaret's team of field inspectors and reclamation specialists have conducted 28,217 well inspections. That puts us about 10% ahead of last year's pace of 37,000 for the year. Again, about 54,000 active wells in the state. So we're running at about 1.6, 1.5 years if we just went around and around to get all of those wells. With that, I will ask Dave just to give you a 2-minute update on the lien process that was recently completed on our field inspection report. And after Dave's report, I will entertain questions.
Thanks, Matt. Good morning, Commissioners. Here to give you a quick update on the lien process improvement related to the field inspection and reporting process. I just want to talk the scope of that involved the documentation of issues found during the field inspection on the field inspection report, how that was communicated to operators, and then the back and forth to get those issues resolved, whether an operator disagreed with the findings or whether an operator agreed and we're working through them, how they work through them, how they communicate back to the field inspection group when an issue has been resolved. So that was the scope of this review. So for 5 full days, so 11 people plus 2 facilitators were locked in a room at the land board for full days, 6 people from representing the operator community, from all different sizes of operators from all different areas of the state, 5 from COGCC, again, following the same concept of different areas of the state, mapped out the current process, identified the pain points, identified the areas within that scope I told you about that either side had a concern on, and then we started to try to find solutions to that. So within those 5 days, it wasn't just identify the problems and leave and find someone else to fix them. It was identify the problems, work the solutions during those 5 days. And we had a steering committee meeting that we had a steering committee that made up of people from the operator community, from the COGCC, and from DNR, and we made 7 recommendations as a team. And those recommendations are going through the process now. We've got a lot of work done on those recommendations. A couple of them involve us working with the Governor's Office of Information Technology to update our field inspection reporting form, to make it smaller, to make the issues identified a little easier for people to find. Right now, they can get a 9-page report, and you might have 2 issues, one buried on page 6, one buried on page 8. We want to make sure those issues are well known up front, first page, so it's easier for the operators to see what issues are. We are actually going to create a new e-form. So Matt said we have 41 forms. Looks like we'll have 42 forms soon. And we're going to work on that as a formal response form. So the operator's going to have a one form, one process to respond to. And as part of that process, we're going to allow them under certain circumstances, factual-based issues, to have kind of a process in place where they can say, look, we have a factual disagreement with this finding. It's not my location. Yeah, the fence is broken, but it's not my fence, stuff like that. Not stuff open for interpretation, but more facts, black and white based. So we're putting a process together on that. The other recommendations really involve us working through guidance documents and developing a process flow. So we're working through the 7 recommendations. We're hoping by the end of March, maybe into April of next year, we'll have all of those 7 recommendations implemented. If anyone wants to learn more, we do have a webpage dedicated to this. It's under the, if you go to our webpage, you go to About Us, and then there's a folder called Lean. If you go into that, you'll see a good one-page summary, a PowerPoint presentation, and then a proposed process flow and other documents. And we're going to be adding to that. So if you're really interested in that, those are good documents. That's my update on that.
Thank you, Dave, and thank you very much for working on that. It looked like that's a pretty valuable expenditure of time and effort. Okay, Mr. Lepore has indicated he would take questions. So if you would like to call his bluff, this would be a good time. Commissioner Palmer.
Thank you, Mr. Chair. I was wondering, I was thinking maybe while Dave was up here or something, if it'd be possible to get an update on staff's work on guidance policies that are currently being reviewed and amended or implemented.
Sure. I was bluffing, so I'll have Dave come up.
Thank you, Commissioner. So from the beginning of the year, we've implemented kind of a process where we're trying to put together a lot more guidance documents on some of the rules that are a little confusing, a little open to interpretation, to try to add a little bit more clarity and consistency and certainty in the process. So we actually created a webpage called Operator Guidance. It's on our webpage. We actually met weekly with operators in April and May, and then went to monthly starting in June. So we've met every month. And what we've done as staff is we've worked on the development of 7 new operator guidance documents. And then we updated 3 that existed before this year to just make them a little more clear and a little more in line with the 7 that we created also. And we've met with operators during those weekly or monthly meetings starting in April and discussed each one of those and got their feedback. Some documents we made very few changes based on feedback. Other documents we completely rewrote based on feedback from operators. So we've done 7 new ones, updated 3 of them. We're still meeting monthly, and we plan to continue meeting monthly. And if operators feel we need to meet more, we can meet more to discuss these. But we are working on 4 additional guidance documents right now, working them through the process, going to get feedback, and then finalize them as we need to. But they're all on that website called under Regulation and Operator Guidance.
Follow up.
Thank you, Director. I would ask commissioners, you might want to go and look at the guidance policy on the webpage and see what's going on, see if there's any input you want. I just was kind of, for some reason, had some spare time over the weekend and was looking through some of that. I'm a little concerned with the guidance policy work on the Rule 1001, the reclamation rules, just because it's a rule that we acknowledged in 2008 was just an initial package, and we needed to work, develop rules around that. And that, yes, they are kind of ambiguous and there's some difficult interpretation, that we really didn't put a lot of effort into that in resolving that in 2008. It might be useful to get to that, just to beat the same drum.
Okay, other questions or comments for the director or for someone the director appoints?
Mr. Chairman, if I may.
Commissioner Spielman.
Thank you, Mr. Chairman. Director Laporte, thank you. The reminder is helpful about the November 16, 17 convening of the commission for the rulemaking hearing. Can you talk please about the December schedule so we can all be appropriately informed and as free of confusion as possible?
Sure.
Thank you.
I think that staff anticipates the possibility certainly that we will need more than the 2 days of hearing on the rulemaking that we have on the calendar for November 16th and 17th. If that proves to be true, Plan A is to continue the rulemaking hearing at our regularly scheduled December hearing, which is on the docket for December 7th and 8th. If we need more time on the rulemaking, my suggestion is that we schedule that for Monday, December 7th, first thing, because everybody already has that date on their calendar and is planning to be there. And I think to the extent that everybody who participates in the November hearings we would want you to be able to participate in December as well. Starting on that Monday seems to accomplish that objective. That might then mean that for the regular business of the December hearing, we would need to extend possibly into Wednesday, which would be the 7th, 8th, 9th. That to me allows us the most flexibility. We could, as long as we still have a quorum on Wednesday, then we can carve off discrete items to put on the Wednesday calendar. If we try to do regular business first and then the rulemaking on Wednesday, which people don't have on their calendars, I'm afraid we might lose some folks. And Commissioner Spielman has indicated to me that that would include him, that he is not available on the Wednesday. So that's the current thinking. Commissioner, I hope that clarifies for you. I can cross my fingers and hope that, there's some possibility we would complete the rulemaking at the November hearing. I would put that at certainly less than a 50% chance.
Thanks, Director. I think that makes a lot of sense. And Mr. Chairman, I would suggest we consider that as we move into the rulemaking and see how it goes.
Good.
But if there are any notices that need to be provided, we still would have time to do so. Thank you, Mr. Chairman.
So you take out your electronic pencil and put Wednesday, November 9th as a
December.
December 9th as a potential meeting day. Okay, anything else for the director? Commissioner Allward.
Thank you, Mr. Chair. I was also as I was reorganizing some of the files associated with this, I came across the minutes from, and this is going to take us back in time, our October 2013 hearing in Lyman. You may recall we heard an issue of reclamation around Thomas Springs, in which there'd been quite a long time and very little had happened. It was still a pretty disturbed site, and staff had put a lot of time into it. And in the order, we had amended it. We had deferred a lot of the fines and asked for a report back from the director on the status of things according to the minutes, in nine months afterwards. So I was just going to ask the director, and I'm springing this on him. So if you can appoint somebody to address it, perhaps we could schedule a little time in the December hearing for a report on that. And I could have forgotten if you did report on it. I couldn't find that.
So you're springing Thomas Springs on me.
Yes.
Really? Mr. Beckstrom, please step to the microphone.
So,
Why don't you introduce yourself?
this is David Beckstrom, Enforcement Officer with the Colorado Oil and Gas Conservation Commission. Commissioner Allward, we have been looking back at that order and are in the process of preparing a report and a follow-up with Thomas Springs. They have as of Friday, submitted a new reclamation plan, given the fact that their previous ones have not taken the way that they had hoped. And we will be making comments and approving that with substantial conditions this week in hopes that they're able to do some sort of reclamation before the snow flies this season.
This is Peter Gowan, Enforcement Supervisor. So the big picture is they did everything that was asked of them by staff in the order and in follow-ups. But the bottom line is the final reclamation has not been satisfactorily achieved. So staff continues to work with the operator for purposes of getting them to the final reclamation standards required by the rule.
This is more of a staff and operator situation as opposed to a landowner being concerned.
There was a complaint by a landowner, but it's my understanding that that issue is no longer present, and you're correct that it's basically a matter between staff and the operator.
Commissioner Allward, follow up.
So thank you, and I think if you could maybe give us an update at the December hearing, maybe a little timeline of what's gone on, that would be great. I appreciate you coming to the director's rescue.
We'll be pleased to do that.
Thank you, Mr. Chair.
Other questions for the director or staff? Hearing none. Let's move then to comments from commissioners. We may have had one or two already, but
I have just one,
Commissioner Benton.
briefly. I noticed in the agenda that we received, or first agenda we received, there were a number of general hearing matters, and there were some that were protested. And then later on, we had an update that noticed that those had been resolved by the operator, and I'm assuming the staff had some input into that as well. So this is just a thank you to the staff and to those operators that were able to resolve those issues without bringing them in front of the commission. Very much appreciated.
Amen.
Thank you, Commissioner.
Other comments from commissioners? Hearing none, we have a slot for audience comments. Ms. Murphy.
Chairman, we have 6 audience comments, and I'll take them in order, starting with Ms. Nicole Johnston.
Hi, my name is Nicole Johnston. Thank you for hearing me today. I'm speaking today regarding docket number 151-000-470. And it's the violation against Burlington Resources Oil and Gas Company. And I wanted to speak today about that. I live in Aurora, Colorado, in a neighborhood called the Adonia. And in the last year, I have become more familiar with oil and gas issues. I started a group, it's over 500 people now, that is called the East Aurora Community Development Group. And what we do with that group is exchange information on oil and gas development in residential areas in the East Aurora area. ConocoPhillips, which is, I'm speaking about today since Burlington is a subsidiary of ConocoPhillips, has submitted in a 30-day span 14 wells, application for 14 wells within a month. This began the end of August. First it was for 4 wells, then it was another 4 wells, and then it was for 6 wells. And I'm a neighbor, a mom, a homeowner, and during that time I communicated the application process to my neighbors to be able to submit public comment. And it is referred to as the Eastern Hills well site, and these wells are as close to 1,000 feet to residential areas in our home. I bring that up because I want to address a couple of things. One is I did speak to Director Lepore. I don't know if you remember me. I came to the stakeholder meeting on rulemaking a couple of weeks ago. Had my 2 kids with me. Wanted to make sure that I understood what happens if I wanted to speak on the issue of mitigating circumstances. So if there is a proposed timeline for when there's going to be drilling, I know that Director Lepore said that staff who comprise of engineers look at the timeline that is proposed. And sometimes there are mitigating circumstances that goes beyond that timeline. And I asked about what had happened if you go beyond those mitigating circumstances, and you had brought up the fines, and I got to open a can of worms for subsequent questions from the audience about the fines. But I bring that up today because you had mentioned, now this is in terms of the timeline, but that I asked, well, what if it continues? What if you give them the flexibility, the mitigating circumstances, and it continues? And you had mentioned, and correct me if I'm wrong, that you would look at that current application and pending or future applications and look at denying those applications if they are violating that. And I bring that up today because with the violation notice against ConocoPhillips and its subsidiary Burlington, there are several inspection violations. And I don't know if I need to, I don't want to repeat what the information that's in front of you because you'll be reviewing that later. But I want you to keep that in mind as, eventually we are going to be, ConocoPhillips will be before you to get these 14 wells approved. And if there's a history, and there is, of violations in terms of inspections, that concerns me as we look forward to approving these applications that are so close to residential areas. So I want to bring that up, that it is on our radar. Like I said, there are 500 and growing every day for this. And if there is a history of these violations, that we need to take those in consideration as we are looking at approving future applications.
Thank you, Ms. Johnson. Director?
Thank you, Ms. Johnston. I do want to just add a little bit of context, and rather do it with you at the microphone, so that if I mischaracterize anything, you can correct me. So this did arise in the context of the proposed new rules for large facilities in urban mitigation areas. And as part of the new rules, staff is proposing potentially a limit on the duration of 24/7 operations. So drilling and completion operations might have a time limit under the proposed new rules. So I just want to give that context, and that was the context your question arose in. If we did impose that limit and an operator could not comply, then sort of what happens.
Okay.
Okay.
Again, thank you, Ms. Johnson.
Thank you.
Appreciate it. Appreciate your involvement with the rulemaking. Thank you.
I'm going to call the next person up by first name because I'm not sure about the last, but Sonia?
I guess I have a long, difficult to pronounce last name. It's Sonia Skakic-Skrima, and I submitted a 510 statement on the same docket number, 151-000-470, and I submitted comments in the 510 statement, taking into account the mission statement of COGCC as I understood it. And so in my statement, I pointed out that that unpermitted flaring adds to greenhouse gases and climate change issues, and that this was the topic of this docket number is unpermitted flaring without authorization beyond flowback period. So I pointed out that it has climate consequences. I neglected to point out that it has health consequences. Flaring is something that has been going on for many years. In Nigeria, for example, is one of the largest flaring countries, and they've noted the health impacts to respiratory systems, birth defects, and so on. And the research has been proceeding apace in this country, showing respiratory impacts, long-term severely raised risks to childhood leukemia and other cancers due to benzene and particulate matter and other chemicals being emitted and incompletely combusted. So I pointed out that that was an issue. So there was a health impact, there is a climate impact, and that there's a waste impact that also does not accord with the intent of COGCC's mission statement to reduce waste, to protect public health and environment, and to also protect, well, public health and environment. So I asked in my 510 statement for the maximum penalty to be levied against this operator, Burlington, a large operator, because they were exhibiting a pattern of operational violations. There are two other violations, two other exact same violations. So two altogether in Aurora and one other one in Arapahoe County. So three in the county. I then spoke with the representative, the administrative representative, Bridget.
Ms. Beckstead? Yeah.
Britta, right. And sorted through some of the responses that had already been made by COGCC. And I learned that the category of violation that the COGCC was planning to downgrade the category from Category 3, which acknowledges adverse impact known adverse impact to health and environment, to a Category 2, on the basis that part of the violation was failure to submit paperwork. Well, failure to submit paperwork doesn't have an adverse health impact, but flaring beyond flowback does. It's like burning money. It's worse than burning money because it has those health impacts and environmental impacts. So by downcoding that category from 3 to 2, you're downcoding and discounting the health of all the people who work around there. You're acting as if it doesn't matter. It can be discounted at will. And yet that impact without liability on the health of the nearby residents continues. So to not have a penalty or to have that penalty discounted is a real insult to the people of Aurora and Arapahoe County. So I went to look at the actual enforcement and violations section of the COGCC regs. And I was, surprised to learn that I did learn that the intent is that the penalty policy is intended to deter noncompliance and to encourage out-of-compliance operators to come into compliance as soon as possible. By discounting penalties, by discounting categories, by offering at the front end to negotiate, settle, and otherwise modify the enforcement of any clear-cut rules, you discount the integrity of that mission intent of the COGCC. You discount and undermine public confidence in the purpose and the goals of the COGCC as a regulatory commission. If the regulatory commission negotiates its rules away at the front end, it's doing a disservice to the people of Colorado. I know that my elected officials in Aurora, my elected officials on the Board of Commissioners in Arapahoe County are under the impression that this regulatory body is very strict and that it has the tightest rules in the nation. We hear that a lot, and they say that a lot. They know that the Colorado legislature decided, what was it, a year or 2 years ago, to increase the penalties, the daily penalties for operators. And they bring that up and say, by God, it's $10,000 a day. It's not
15.
Okay, up to $15,000 a day. And, they've increased the penalties and they're a tough group and they enforce. But then when you read through the entire enforcement and penalties section, you come to an entirely different conclusion. I just want to make 2 more points. In reading the enforcement language, it states specifically that there are aggravating circumstances that need to be taken into account to determine, for example, whether an operator is acting in willful disregard. I was told by Britta that the 2 other incidents that are on record with the COGCC of violations, exact same violation, flaring beyond flowback, that they weren't counted in the administrative assessment of, what does this particular violation represent, because they didn't occur at the same well site. That's kind of like, you get 3 tickets for running red lights, but only 1 counts because the other 2 were at different stoplights. That's a little bit odd. I was told that's because those haven't yet come before you, but clearly you're aware of those violations. But there are other aggravating factors listed that the violator acted with knowing or willful misconduct. Burlington is not a small operator. They knew they were acting in violation of the rules. Did the violator have control over events? Yes, of course. They could have not flared beyond flowback. Whether the events constituting the violation were foreseeable, of course they were foreseeable. They could have changed their operations at that well site. Whether they could have taken reasonable precautions, yes, they could have planned differently. So according to your rules, they did act with willful disregard. And yet, I was told by Britta that it would, in all likelihood, the category would be downgraded from 3 to 2, that the penalty would be downgraded, and until the other violations came before you and met the within 2 years rule of other violations, that it would all be heavily discounted. I was very surprised about that, very disappointed. But frankly, when I read the final portion of the guidance disclaimer for this entire section in the COGCC, I can't begin to express how alarmed I became. So it says at the end of the enforcement and section, the policies and procedures set out in this document are intended solely as guidance. This document does not contain rules or otherwise binding requirements. Nothing in this document creates any substantive or procedural right enforceable by or in favor of any person or entity. The Commission reserves the right to vary its activities from this enforcement guidance and penalty policy at any time and in its discretion. The policies and procedures set out in this document are intended solely as guidance. The document does not contain rules or otherwise binding requirements, etc. When you state at the tail end of your enforcement policy that this policy is purely guidance, it's like a cerebral, we could do it this way, a hypothetical. There are no clear set of rules. That's disturbing. That's deeply disturbing. There is no way. It gives the appearance at the front end when you read the rules that there are rules. But when you get to the very end, it tells you these are not rules. I'm very disturbed at that. I think anybody who read that would be. I do intend to bring that to our legislators and local elected officials' attention. This clearly needs it needs change. If we don't have rules, we don't have a regulatory agency if you don't enforce the rules. It's not even a toothless tiger. It's a protein, can be whatever industry wants it to be organization. That's not reasonable. And I ask you to take a look at that, as well as enforcing the maximum penalty, in this case, for this repeat violator, in order to uphold what the public expects you to do based on your intent, and that is to deter violations by a set of coherent rules. So again, I ask you for maximum penalties in this case, and I ask you to take a look at your rules to make them actual rules in terms of enforcement. Right now, it clearly says they are not rules. They are mere suggestions. That's not good enough for our state. Thank you.
Thank you, Ms. Sonia. Okay, next.
Chairman, we have Pat Dunn, Randy Webb, and Rebecca Ote, and they all have noted the same subject matter as what Ms. Sonia just presented on. And to help us keep on track, I forgot to note that if you would like to request that people limit their comments to a specific amount of time.
If that will work, we would appreciate not going over the same details, but you can make a quick point relative to supporting Ms. Sonia's request.
Good morning, my name is Pat Dunn. I'm referring to docket 151-000-470. I've lived in Aurora for over 35 years, and I'm very concerned about Burlington's well violations concerning flaring at the wells in Aurora. I would respectfully request that the COGCC firmly and expeditiously fine Burlington to the fullest extent possible.
Excellent, Ms. Dunn. I commend you. Thank you. Thank you.
I'm Randy Webb, and I live in Aurora. I'm referring to this same violation by Burlington, subsidiary of ConocoPhillips. As a Colorado citizen of Aurora, I know that the Aurora City Council relies upon the COGCC to protect its citizens from harmful effects of oil and gas development. At recent forums, candidates for the upcoming council election referred to their reliance on you for protection. Aurora's air has been given an F grade by the American Lung Association already, so any more emissions are alarming. The Aurora City Council and all our citizens are counting on you to uphold enforcement of violations. We expect that fines will be sufficient to deter future violations, especially when there is a pattern like this of flaring beyond flowback. Administrative downgrades for violation categories and penalties are neither protective nor acceptable. ConocoPhillips is requesting more and more permits for wells in Aurora. So now is the time to enforce Colorado's acclaimed strict rules, such as they are. And now is the time to hold ConocoPhillips and its subsidiary Burlington to those strict rules.
Thank you very much, Ms. Webb.
Thank you.
Good morning, I'm Rebecca Odie. I'm also speaking on the same docket, but I'm going to address it from a different.
You said your name, but
Rebecca Odie. I also live in the Adonia subdivision, same as Nicole. So I'm going to address this from a different issue, more of a personal issue. I have actually spoken about this well that is in violation during city council meetings, Aurora City Council meetings, because I can see this well from my kitchen window. So though it's only been addressed in the violation of a matter of a few weeks, I actually saw it flare for almost 24 hours for months. I was affected by the lights from the site shining into my bedroom window, sounds at night, sound like a semi was parked behind my house. So literally caused feel like my brain was vibrating at my skull. So I'm glad that you're addressing the issue of possibly changing operations not being 24 hours a day. That would be nice. Also, I just wanted to address that it is these reasons why the residents of Adonia have addressed numerous times why there really should be real-time monitoring. It's not only to allow the residents to know what we're being exposed to at any given time, but it also allows the oil and gas industry to be held accountable to what they're releasing so that you will understand if there's excessive flaring without necessarily inspections. Because I do know that inspections aren't done regularly on every site all the time because you have a limited number of inspectors as per number of wells in the county. So I also want to address that there are times too, because of the excessive flaring, that we can smell a rotten egg smell in our neighborhood. And I do know that this is a hydrogen sulfide, which is produced during the operations. So that is another concern. And as Nicole mentioned, we've had numerous applications put in. And from my understanding, there is one that is recently being put in, and the half-mile radius is actually going to cover some of our actual subdivision. So residents are supposed to be given notices, but it's getting closer and closer. And if it was more than a mile from my house and I was being that affected, it is going to be understood that these neighbors that are even closer to it are going to be even more affected. So just like everybody else has been asking to set up here, I would like you guys to take into consideration these kind of things when looking at these violations and really take into consideration the fullest extent of these violations to try to make sure that they don't continue to happen. So, thank you.
Thank you, Ms. Odine.
Chairman, our final comment is from Amanda Harper.
Good morning. I have a couple of different items.
Ms. Harper, would you go state
Oh, I'm
your
sorry,
name? So-
Amanda Harper. I just come here so often. I know you guys are familiar with me. So I signed up for party status with the rulemaking, and I'm not sure I'm signed up. I went through the process, but I've never gotten an email back that confirmed that I have that or where I'm supposed to go to make my comments. Can someone help me out with that? Yeah. Oh, okay. So there's a process for me to put my comments in. Is that on the website? If I study the website? Yeah. Okay. So so thank you. Then I want to go back to a point about me being a Weld County citizen and how there seems to be a logic gap somewhere here, because I live in Weld County, and the LGD does nothing for its citizens to help and listen to them. We asked for CDPHE studies. We asked for a lot of different things for help from the LGD, and we didn't get it. So I've been coming to the state, as you know, over and over, month by month. I've been asking. I've sent probably hundreds of emails. I've written documents. And right now, I know that those wells are on hold, the 24 wells that are supposed to be near our house. I have no idea why they're on hold, but there's certainly not anything to do with the LGD or what he did. And it's in your mission statement to help citizens, but Weld County has a barrier that you can't help citizens across the Weld County line. Do you know what I mean? I can't get help from you guys because Weld County says you're not allowed to help the way it's all set up. So where do we go for help? I asked this at the other meeting. last week. Where am I supposed to go for help beyond you guys? Anyone have an idea? Do you have an idea, Mr. Compton?
At this point, I don't have an idea. We're struggling right now trying to resolve how much the county has control and how much the state has control. And I think I'm hearing you say you want the state to have more control, the county less, because the county's not meeting your
Well,
expectations.
what do we do about that conundrum? Because other counties, Boulder County, Larimer County, those counties care about their citizens. Weld County does not. They don't care about their land or their citizens, as far as I can tell. None of the commissioners do, and the LGDs certainly don't.
Well, I don't know if the hearing, the rulemaking hearings that we are embarking on may speak somewhat to that issue. I'm not sure they'll totally resolve it, but they may speak to that.
Well, it concerns me then that I hear today that the LGD trainings are going to be in Weld County. That's scary to me, to have a whole state full of people getting trained by Weld County LGDs.
I think that's a state, that's a COGCC LGD liaison is going to conduct that training for Weld County.
Is the public welcome to that?
I'm assuming they would be. I don't want to speak out of turn. Director, I'm assuming public could.
Yes, the public can attend.
Okay, so will that,
Mr. Chairman, if I may, I believe this opportunity on the agenda is for us to receive comments, and I know the staff has made themselves available to Ms. Harper and to anybody here today, as always, to answer questions. I think that's a more appropriate forum. We continue to hear what's on people's minds, and the return of answer of questions take place with staff thereafter.
Duly noted.
Thank you, Mr.
what
Chairman.
does that mean?
Say again?
It means I can't ask questions right now?
If you
Okay,
have
that's-
questions for staff, we think it'd probably be more appropriate that you ask them, and Ms. Murphy has offered to meet with you here
Yeah,
momentarily, and you can address those there, and then limit your comments briefly to
okay.
concerns, broader concerns.
But since I come here and I always make statements and I never get any feedback, I never get any feedback.
You never get
From
anything?
you guys, I don't. This is the first time because I'm trying to engage it a little bit more. And it's the same, these people came up here and said statements, but will they ever get any kind of comment back from you guys? About
From you
everything
guys,
they br-
you guys are the
commissioners.
commissioners. Okay.
Right, sorry.
Generally speaking, the commissioners will work through staff in responding, so
Huh,
I can't tell you that.
yeah, I've never gotten a response back since December. So, well, from my statements here, I haven't. Have I?
But we'll
You're
look
saying
forward to
no?
you meeting with Ms. Murphy, try to
All right,
resolve
well,
some of
I'm
those.
just, I just want some kind of comments back. I've sent things around and never heard back from you in the last few months. So then I just have a few things to give for everybody to take a look at, and that'll be my last thing today. The first thing is a speech that I gave at the Stop the Frack Attack on the Capitol steps, and it's this document, and I'll give you that. And the second one is an article, I'm sure since all of you are, you must make efforts to look at all sides of the issue of fracking. Like you study all the different points of view from all the different organizations that exist in the world. And I thought I'd help you out with that. I have a list of 58 countries that have different organizations. And you could go to it's a global frackdown that's going to happen in Paris in November. And I have a list of all the different organizations from all the different countries and states in the United States. So I thought you might want that. So you have access to the information that's not just from the industry or from these poor citizens who come and sit here every once in a while. I feel like. Then I have one more. I'm sure you've all heard of Chris Hedges. He's an amazing intellectual who looks at the bigger patterns of things, like releasing unbelievable amounts of methane from various parts of the fracking process that's happening, dramatic methane emissions are coming out. And I have an article here called Death by Fracking by Chris Hedges, and I thought you might want to read that. And then I have an organizational sign-on letter here that's about to be able to sign up and become a person that wants to protect our climate. And I think that as the COGCC, you guys should be caring about our climate because you have it in your mission statement and your mandate. So I thought you might just want to look at what people are looking at to try and push back against what's going on here, the COGCC. I know you're strict, but as that one woman pointed out at the very end, there's this out for the industry. And I think it's laced all over the place like that through. So anyway, that's it for now.
Thank you very much, Ms. Harper. I'm sure Ms. Murphy will see that those items are available to commissioners.
Thanks.
That comes to 6 is by my count.
Me too, sir.
Thank you very much.
Mr. Chair.
Commissioner Allward.
Thank you, Mr. Chair. I just want to assure citizens of Colorado that even though this venue doesn't lend itself to commissioners responding to audience comments, that I know this is the part that I find most important, and especially when we move hearings around the state, that the comments that come before us do influence how we look at making decisions, that it makes it real, and that it's not just numbers and documents and names, but that it affects real people. And so coming before us and expressing your concerns does have an impact, at least to me, and I'm sure to my other fellow commissioners. So thank you very much for taking the time to come before us. Thank you, Mr. Chair.
Thank you, Dr. Allward. Okay, we are at the consent agenda, and I'm just looking around. I think we're going to dive right in to the consent agenda. Ms. Murphy, any direction for us?
Chairman, I would ask if there are any recusals first, and second, if you want to take enforcement separate from the general applications, you're always welcome to.
I'm going to unilaterally make a decision to take enforcement separate at this point. So are there any folks on the commission that need to recuse themselves from any of the items on the consent agenda?
Mr. Chair.
Dr. Allward, Commissioner Allward.
Thank you. I need to recuse myself from all the items in Group C, which is one item, docket number 151-00609. So I'd appreciate if we just had that agenda item considered separately from the rest.
Okay. Others?
Mr. Chairman, if I may.
Commissioner Spielman?
Thank you, Mr. Chairman. I do not need to recuse myself from any item, but in an abundance of propriety and to avoid the appearance of a conflict, I am going to recuse myself from certain items in Group B, Group G, and Group K, those involving applications from Extraction Resources. I have no financial interest in the outcome of those, but others at my law firm do represent Extraction. I don't know what they do. I don't know the nature of that representation. I am screened off it. And they are here with counsel not from my law firm. But again, to avoid even the appearance of impropriety, I will abstain from voting on matters involving that applicant.
Duly noted.
Thank you, Mr. Chairman.
Okay. Are there others? If not, I will entertain a motion for approval of the consent agenda exclusive of Group B, C, G, and K.
So moved. Second.
Okay, motion for approval and a second. Any discussion? Hearing none. All those in favor of approving the consent board agenda with those exclusions indicate by saying aye.
Aye.
Opposed, same sign. So those stand approved. Now let's look at Group B. So Commissioner Spielman, actually, maybe we could do B, G, and K together. Mr. Spielman has requested recusal from those. So I'll entertain a motion for Group B, G, and K.
So moved.
Motion to approve
Second.
and a second. Any discussion? Those in favor of approval of B, G, and K indicate by saying aye.
Aye.
Opposed, same sign. They stand approved.
And may the record reflect, please, Commissioner Spielman did not participate in that vote. Thank you.
Ms. Murphy will make that happen.
Thank you, Mr. Chairman.
Group C, Commissioner Allward has requested recusal from that. We'll entertain a motion for Group C.
So move, Mr. Chairman.
Motion to approve
Second.
and a second. Any discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. So Group C stands approved with the notation that Commissioner Allward was obstinate and wouldn't vote, or something to that effect. Thank you very much. Enforcement matters.
Mr. Chairman,
Commissioner Wolf.
just in deference to the testimony that we heard, I would ask that the Burlington Resources Oil and Gas docket number 151000470 be removed for separate consideration so we can hear from staff.
Thank you very much. And without anybody objecting, I think we'll just do that.
Mr. Chairman, if I may.
Yes, sir.
Thank you, Mr. Chairman. I would ask that, apologies, I'm trying to find the docket number. Thank you, docket number 151000482 also be removed from the group, and I will abstain from voting on that matter.
Tell me the operator.
Beg your pardon, Mr. Chairman. Extraction oil and gas.
Okay. Okay, we have two items that will be removed from our consideration of the enforcement group matters consent agenda. That is the Burlington Resources and the Extraction Oil and Gas LLC. The remaining items, is there a motion relative to those?
So moved.
Motion to approve those remaining items. Any, a second?
Second.
Discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. Those items stand approved. Let's take extraction oil and gas, from which Director Spielman has requested recusal. Is there a motion relative to that item?
So moved.
We have a motion for approval of the enforcement matter
Second.
and a second. Any discussion? Hearing none. Those in favor of approval of the enforcement matter relative to extraction oil and gas indicate by saying aye.
Aye.
Opposed, same sign. They stand approved. Burlington Resources is the remaining item on the consent agenda. Enforcement matters. How would you like to proceed? Perhaps we could hear from the hearing officers to present their case. So we'll just go with, oh my goodness.
Good morning, Commissioners. Jeremy Farron, Enforcement Officer. Berta Beckstead, Peter Gowan. We all worked pretty closely on this AOC, so I'll try and address some of the points made, but because enforcement only gets a small piece of the bigger puzzle, I'm not going to address everything that was commented on. And I also know that the operator is here and represented by counsel, so if you have any questions for them too, they can come forward and answer some questions. I just want to give you sort of an overview of what we were thinking when we negotiated this AOC. And the first is that this was unapproved flaring. It wasn't venting. It wasn't anything that staff considered to be a risk to public health, safety, and welfare. And so with that in mind, it doesn't fit into the pigeonhole of a Class 3 violation. And so when we look at the language in 523, it just doesn't fit in the Class 3 realm. And so we reclassified it as a Class 2 because that's where it fits. Same with minor versus moderate, same sort of thought process. The impact was minor. And so that's what we did. We reclassified it. We considered it a moderate. We also needed to reconcile this case with the prior order, which was entered in April. Similar case, similar reclassification. I've actually spoken with Deputy Director Coleman about just reclassifying 912 because where things are done in an appropriate manner, it's not a Class 3. So I think we've mischaracterized that rule and we've ended up having to reclassify things. So if that happens, you guys will be the first to know, I'm sure. So that was the first piece. The second piece is whether we should have proceeded with a pattern of violation in this instance. And the same thing, we're constrained by the rule, which the rule 523 again requires that a pattern of violation look back at past orders. And there are no past orders in this instance. In fact, there's no past NOAVs. This is the first NOAV that Burlington has ever been issued. And so with that in mind and sort of a holistic view of this situation, we think this penalty is appropriate. We also ended up with a suspension and a compliance plan moving forward that will pull in additional wells. We'll have a suspended penalty hanging over their head for 2 years, and typically we stop at 1. And it also includes a different rule, 805, which is directed more at the waste issues that were mentioned earlier. So again, we think this is an appropriate penalty, and we ask that you approve this AOC.
Mr. Chairman?
Mr. King?
Are there further violations that occurred after this that are under consideration and evaluation by staff?
So there's no pending NOAVs. I'm not sure what engineering is looking at moving forward, but so far as I know, this was the only NOAV. This is the only one in the system.
So when the public was talking to us about other incidents, we're not sure what those were referring to, other violations?
Yeah, there's some inspection reports with action required. I haven't seen anything for violation inspection reports. And again, there's no other NOAVs. So that might be a conversation with staff to see if they're going to issue additional NOAVs. But
and this is now turned into a hypothetical, but if there are issues that come up later, this order today would be a foundation that you could consider on those other violations, whether they're pending or occur at some point over the next 2 years.
yes, so
That would be an aggravating factor on those.
definitely. So first of all, the suspended penalty would be unsuspended immediately, and they would be facing additional daily penalties going forward until they corrected whatever problem.
Commissioner Benton?
So what I just heard you say is that the suspended, because it says here it's suspended pending their compliance with Rule 912B and 805B3 at all wells that operates for 2 years. But I thought I just heard you say if there's other things that crop up, you may also look at removing the suspension on the 15,000.
No, you're right. It's tied to those 2 wells. If I misled you a little bit, but
Yeah, I just was looking for clarification on that.
yeah,
Thank you.
it's tied to those 2 rules.
Commissioner Allward?
Thank you, Mr. Chair. I'm looking at the findings in front of me, and finding number 2, which ends on a date, COGCC staff observed Burlington flaring the well. Was there a reason staff was there, or was this just by chance?
I believe Mike Hickey's sitting in the front row. He could probably answer it better. I think he was driving by.
Is that,
That's correct. I was just driving by. It was visible from I-70.
so it's just by chance that we happen to have a staff member there that were aware of this?
Yes.
Okay.
Other comments, questions? Commissioner Hawkins?
I just have a question about the Class 2 versus Class 3 violation. And I guess the concern is if the guidance document places this as a class 3 until that's officially changed, how can we just call it a class 2?
So in the policy document that was looked at a bunch this morning in comments from the public, there's a whole section on reclassification where if a violation of a discrete subpart is not of the same nature as the broader category. And to be honest, I wasn't involved when 912 was classified as a class 3, but I have a feeling they were thinking about venting, which is always serious and always dangerous. And so when you have unapproved flaring that's done in a responsible manner, it's a different category of violation.
And I know when we did the rule establishing violations and the matrix that set out the penalties that were going to go with class 2 and class 3, we had some kind of guidance or an indication of what was going to go in class 2 and class 3 at that time. And it was decided to put it in a guidance document rather than in the rule.
There's also language in the rule 523, which sort of bound us here because we looked at it and we said, this just doesn't fit that definition. And so that's why we reclassified it down to a 2.
Well, that would be my only concern is that if we have a rule and we have language in there, that we need to be consistent with the language that we've agreed on.
And I think we have, and again, this was related to a prior enforcement matter where a similar reclassification, it doesn't fit well into the class 3 category.
Other comments, questions?
Mr. Chair.
Commissioner Allward.
Thank you, Mr. Chair. I would just suggest that when staff becomes aware of a violation just by happenstance, that one might want to consider whether mitigating factors are really appropriate or reductions or inducements. I find that a problem. We're only aware of this because of by happenstance.
Thank you. We will.
Okay. Your colleagues want to support you, or you're the person?
I'm the point person, apparently. They were nodding their heads.
Okay, we have Commissioner Wolf.
One more question. What was the operator's reasoning or rationale for the flaring?
Michael, correct me if I'm wrong, but I think just unavailability of a pipeline.
Yeah, I'm Mike Hickey. I'm Northeast Area Engineer. And yeah, the pipeline was still under construction, being tested. It just wasn't quite ready yet. And just a scheduling issue that they have corrected now. Moving forward, they will make sure that their pipeline scheduling is part of the drilling program so that the pipeline is ready when the well is ready and that the flaring won't be necessary.
We do have counsel from the company if you want to hear from him.
Oh, I think so, because now I'm curious that if that was the case, was there a potential issue with a well? Why you couldn't just leave the well shut in for an extra week or 2?
We'll invite, that's okay, we'll invite counsel come up.
Yeah, I'm sure he can answer that better than me.
Good morning. John Jacobs with Davis, Graham, and Stubbs for Burlington Resources. Mr. Chairman, Commissioners, Director Lepore, I do believe there's some additional factual information that might help with answering some of the questions that you've raised. Burlington does support your approval of the AOC at this time, but in particular, want to clarify that the basis for the flaring and the company's position heading into the NOAB and the negotiations, which is all very well documented in the file, the enforcement file that staff has maintained in developing the AOC is that these are wildcat wells. This is productivity testing. We're still trying to evaluate this resource and these leased properties. That these were very well controlled, past flowback production into temporary tanks that were controlled with vapor capture and combustors, flares, for a limited period of time, that there were extensive communications with COGCC staff that's well documented prior to Mr. Hickey's drive-by observation of a flare. And it was our understanding, because this was productivity testing, we certainly believe it fits within the exception to the approval of flaring for productivity testing in the existing rules, and that these are wildcat wells, that there is no violation whatsoever. Now, when faced with the NOAV, when faced with concerns communicated to staff and concerns raised by staff, we've reached an offer in compromise here to avoid an expensive and time-consuming and uncertain result in a hearing, an evidentiary adjudicatory hearing before this commission of whether there's even a violation under the current rules or not. And we've also offered, in addition to taking a 5 figures penalty and a 2-year suspension on rules that aren't even at issue, such as green completions, again, these are wildcat wells. In addition to that, we've offered to use enclosed combustors, also not required for this type of operation under the rule, but we're willing to do that. We're giving things beyond the requirements of the rules, which is really the essence of compromise and settlement. So there is much more here than meets the eye in the AOC. It's all accounted for in the file. We wish to avoid a hearing before this commission on this as well, and we're willing to pay the fine. We're willing to live with a suspended fine, even for a 2-year period, which we think is excessive, even if there's a green completions violation, which shouldn't really be an issue since that wasn't even alleged in the NOAV. And this encourages compliance. It deters non-compliance, even when it's disputed. And of course, Burlington does not admit to liability, but is compromising in the AOC at this time. So there are 2 sides to the story. This could go either way under the rules as written. Staff is getting more than they would if the rules as written were enforced in a hearing. And we'd urge you, under these circumstances, to approve this AOC. I'd be happy to answer any other questions as well.
Counselor, your willingness, your company's willingness to accept the 2-year probationary period, if I could call it that, would seem to suggest that you're fairly confident this kind of situation is not going to crop up in the future.
That's correct. And I would add that I wanted to correct Mr. Hickey again, just briefly. These wells, after productivity testing, and in the future, this will be with sundry notices filed. That's the paperwork nature of this violation. The flaring would have gone on. It's just was the sundry filed for division approval. We didn't think it necessary because of the wildcat well status and the productivity testing, which had been discussed with staff. But in this circumstance, those wells then after productivity testing, which will help better control them and to manage and develop that resource during the useful life of those wells, they're shut in for pressure buildup. They aren't attached to sales lines. And because we're still evaluating this area, sales lines aren't available. But once those wells do produce after pressure buildup, those sales lines will be in, and permanent lease dedicated tanks, separators, facilities, combustors will all be in place.
Okay. My only other comment I would make, and probably to Commissioner Allward in particular, that even though there was a somewhat serendipitous nature to the discovery of this, I think it was good that we have some folks that are driving around in those communities for whatever reason are able to notice things like this happening. So appreciate that. All right. What direction do you wish to proceed on this?
Mr. Chair,
Commissioner Wolf.
I'm comfortable after obtaining more information from all sides and would make a motion to approve enforcement as recommended by the staff.
Second.
Have a motion and a second. Any further discussion?
Mr. Chair.
Commissioner Allward.
Thank you, Mr. Chair. Just one brief or one short observation to operators who are operating in close proximity to the people of Colorado, and especially residential areas, to get out front of this and communicate with people so that they're aware of what's going on. These are the sorts of things that motivate people to petition the state and petition the voters to take action. And if you're uncomfortable with the direction that the residents want to push the state in rules and regulations, get out in front of that and work with all, not just Burlington, but all operators who are in close proximity to especially residential areas and urban areas.
Okay, thank you. Any further discussion on the motion? Hearing none, those in favor of approval of the enforcement matter with respect to Burlington Resources indicate by saying aye.
Aye.
Opposed, same sign. It stands approved. Thank you all very, very much. Appreciate it
Mr.
for the
Chairman.
clarification. Our next item is a presentation from CDPHE. Prior to that, I think we will have a 10-minute recess. I guess we're okay. You look really good. I'm going to believe you. Your credibility just. No, not marching. over exuberant usage.
You do this? Yeah. You borrow my cup.
Unpermitted use. That's it. Next on our agenda, we have a presentation from the Colorado Department of Public Health and Environment. So and since Ms. Murphy is not here to introduce you, you may have to
I can introduce them as the best part of the hearing.
there we go. What better introduction?
No bias
Go
whatsoever.
right ahead and proceed.
All right, fantastic. So my name is Mike Van Dyke, and I'm the branch chief for environmental epidemiology, occupational health, and toxicology at CDPHE. And we're here today to introduce a new program, the Oil and Gas Health Information and Response Program. And with that, I'm going to introduce Dr. Daniel Vigil, who is the manager for this program. So take it away, Dan.
All right. Thank you, Mike. Commissioners, thank you for inviting us, and good morning. I attended one of your lively rulemaking sessions a couple of weeks ago and learned about 2 task force recommendations that you're implementing. Seems like a tough process. Meanwhile, we've been able to much more quietly work on a couple of the recommendations that I want to tell you about this morning. Brief background, many of you know that for years COGCC has received multiple citizen complaints about oil and gas each week, and many of those involve concerns about possible health effects or even symptoms that a person attributes to oil and gas. Other agencies also receive similar calls and emails, including the Air Pollution Control Division, the Office of Emergency Preparedness, and local public health. Therefore, this was a topic that came up for the task force, and it resulted in recommendation number 31B, which calls for a public response program for health concerns, mobile air monitoring, and health risk assessment. So CDPHE has developed a new program, which we're calling the Oil and Gas Health Information and Response Program. We will have 3 staff. I'm the program manager and physician. We have now a toxicologist on board, and we will hire a case manager by mid-November. The mobile air monitoring unit is being designed and will be operated by the Air Pollution Control Division. We'll work closely with them, and the health concerns that we receive will contribute to decisions about where to conduct air monitoring, but we will be managed separately. We're also working on recommendation number 41, which calls for a clearinghouse of oil and gas information. So that's some background. I want to address 3 general questions and show you our website, and then Mike and I can answer any other questions that you have. So those 3 questions are, how will we respond to health concerns? How do we find out about health concerns? And what are our plans for the future? When we are notified of a citizen who has a health complaint, we will contact them to discuss their complaint or concern and collect information. In some cases, we'll take further steps, which might include talking with their doctor, asking them to complete standardized surveys on symptoms and quality of life, possibly deploying mobile air monitoring, or working with your inspectors or CDPHE inspectors. Now, honestly, we don't expect in many cases to be able to identify specific causes of people's symptoms, but we'll discuss with them what we know and what we don't know, and we hope that in time our program will contribute to knowledge about possible health effects. How do we find out about a health concern? We have both a call line and a website. Our call line is part of CoHelp, which is a single phone number for multiple health topics that is answered by agents during daytime, evening, and weekend hours. In the case of an oil and gas health concern, the agent will forward contact information to us and we'll call or email the citizen.
Our website has a self-referral form that citizens can fill out, and we will get back to them. And of course, health concerns will continue to come through COGCC and other agencies, especially if a citizen mainly has a non-health complaint, but also has some health concerns. We've worked with Megan, your complaint specialist, and she will directly send us, email us information about health concerns. We've made similar connections with other agencies as well. So what are our goals for the future? We've set up a website to record and track the information that we receive. Over time, we'll analyze this data to look for patterns and relationships. We especially want to compare it with information such as air monitoring results, results of surveys on symptoms and quality of life from the general population, hospital data, phases of production and development, etc. We have begun a formal literature review, and we will post those assessments on the clearinghouse. And all of this in time could contribute to community level health risk assessments depending on available resources. So with that, I'd like to show you our website. This is the main page. On the left here, it's just a brief info show answering some simple questions that mostly direct people to these three items on the right. The frequently asked questions, which has our contact information at the bottom, phone number and website. It's a little bit small right here. This is the self-referral form that I mentioned. So individuals can answer questions about whether they have health concerns or non-health complaints, whether they have questions, fill out the information, and we'll get back to them. And then finally, this is the clearinghouse, which currently contains primarily links to some outside sources, especially within CDPHE and COGCC. We will be adding our own analysis of existing research and things like that as we move forward. Any questions?
Commissioner Ben.
How do you plan to publicize this so folks, you sort of broadly know that it's out there and they can use it?
Well,
and yeah, but then quit calling Director Lepore. Thanks for that.
Well, we're starting with meetings like these to notify partners of the existence of our program and the way that that the public can contact us. As we get used to the operation of our program, we do plan to more publicly announce, including press release, and in time we'll also have public meetings to notify people.
This is just the pilot phase, so it's a soft launch, so that again we're just getting a sense for getting the kinks out. We also want to be closer to the availability of the mobile unit, so that we can be able to send out a team if and when mobile monitoring might be indicated. So probably January or so is when we're looking at doing the harder launch of this.
But it is available right now.
It is available right now.
So our LGD liaisons, as they have community discussions, could certainly offer that as well. Thank you.
Yes.
Can you guys put that on CML and on CCI? I know being the mayor of Fort Lupton, the complaints I'm going to get are from citizens, and if I can direct them to you rather than to Mr. Lepore. But to be able to get that information out to the municipalities and the counties, both of those organizations would go ahead and make some kind of a release.
We could definitely get that out. As soon as we figure out what exactly that is, we could get it there.
We have already presented to the local environmental health directors, and we're working on getting on the agenda for the public health directors meeting as well.
Excellent,
more.
excellent. You have a good program. I'm looking forward to that. In a tough job, realizing the genetic diversity of our population and the accompanying different physiological response. It's a tough job. So I appreciate your doing that, taking on that task. And besides, my understanding was from your presentation, you're the kind, unlike Dr. Allward and myself, you're the kind of doctor that can actually help people.
We really hope so.
Other comments? Commissioner Benton?
A brief one, sort of the list about what to do in the future. I'm assuming somewhere in there an app that works for iPods and Androids will be in the works.
Oh, in fact, our website is set up to be scalable, to work well on other devices. So feel free to test it out. Let us know if there's any problem.
I think Commissioner Allward has been doing that regularly. He tests our new stuff out.
Okay, thank you very, very much. We appreciate that. Appreciate CDPHE's willingness to take on this task.
I just wanted to add one more thing. We will be working with the COGCC inspectors to make sure they have all this information as well, including having information cards that they can hand out while they're out.
Wonderful. Excellent.
Thank you.
Thank you. Next item on our agenda, I believe, Ms. Murphy, is Anadarko's remediation of the Carl A. Peters well.
That is correct, Chairman. I believe our Greg Duralno is going to make a brief comment at the outset, and then Anadarko was going to present, and Mike Hickey was going to be present to provide an additional kind of review of what staff did.
Thank you. Good morning, Commissioners. Good morning, Chairman. Today, up here with me are representatives from Anadarko Petroleum. They will be presenting on a rather unique well remediation project, unique in the setting primarily. See, I have Andy Little, Alex Holman, and Kurt Weaver from Anadarko, and as Julie said, Mike Hickey and I will talk about it from staff's perspective. So with that, I'll let them move into it.
Thank you. Good morning, Commissioners. Thank you for this opportunity. Thank you, staff, and thank you to the public for providing us this opportunity to share the Carl Peters with you. As Greg mentioned, Andy Lytle is here. He's our Regulatory Affairs Manager. With a lot of interface, and I think a familiar face to most of you here. Also helping out is Kurt Weaver, a Manager of Operations in the field, particularly our well work on the vertical program that numbers in the thousands of wells for us in Weld County. And I'm Alex Holman. I work in our stakeholder relations function, facilitating the Wattenberg asset. Anadarko is a company that is big believers and big adopters, big contributors in the space of our core values. It's our belief and our hope that no matter how you come into contact with a team member at Anadarko, you'll see these core values in action. Not just something that we talk about or post on a wall, but something that we challenge ourselves with weekly. And we believe it's really the foundational element that made what we believe a pretty successful operation with regard to the Carl Peters. Hopefully these elements, servant leadership, open communication, people and passion, commercial focus, come ring true for you in this presentation. The agenda that we're going to cover here has a lot of pictures. That's one thing we really wanted to bring home for the people that weren't able to see it in person. So there's going to be a lot of that through the several slides coming up. We're going to cover the background related to this well. We're going to talk about the locate, which was a pivotal piece of business in the remediation. We're definitely going to touch on the workover itself at pretty high level. Certainly would entertain questions at a more technical or granular level if you have those. And then we're going to touch on the engagement that was conducted ahead of, during, and continuous along with this area of our operations.
So just a little high-level background on the Carl A. Peters well. It's a well that's located about 1 mile south of the Meade town limits. It was drilled by Amoco in the early 70s. It wasn't completed. Amoco then made the decision to plug and abandon the well. Fast forward around a decade or so, a company by the name of Caribou Energy, who's the operator of record in this particular case, re-entered the well bore with intention to complete. It's my understanding they did not have funding, and the commission ordered Caribou to plug the well in 1987, in which they did. Fast forward a few more years to 2012 through 2014, Anadarko proposed and permitted a number of horizontal wells, east to west orientation, just offset the Carl A. Peters well. And this is sort of when the well came on our radar, and in particular under the commission's horizontal offset well policy. Our engineers did a review along with the commission's engineers, and it was determined that in order for us to move forward with our horizontal development, we would need to re-enter and re-plug this well. We didn't feel like the previous plugging that occurred in the 80s was sufficient enough. And so that was the determining factor. And so really what we walked away with was a set of complexities. Number one, the proximity of the well, which Kurt will get into in detail here in a minute, but also the fact that this was going to have to be a partnership between the commission and Anadarko, being that Caribou was the operator of record and this was deemed as an orphan well. And so, yeah, really tremendous collaboration throughout the project. We worked better part of 18 months with the surface owner, the homeowner, to gain access to actually locate the well. We had lat-long coordinates from the commission's website to work off of, but quite frankly, did not know the exact location of the well. And so worked with those individuals to gain access and then to provide that assurance that during operations that there would be accommodations made available for them, and that rest assured restoration of their landscape would take place at the end of the operations. And then importantly to note, the collaboration with the commission, again, being an orphan well and being that Anadarko was not the operator of record, this became a partnership. And we worked with Mr. Geronimo, Deputy Director Coleman, Director Lepore, Jake Matter, Diana Byrne, among others, to outline the series of events that would ensue. And that really had a lot to do with not only the operations, but engagement with the homeowner and the HOA, which Alex will talk to in a minute. But what this all led to was a tremendous execution of operations, a great partnership between the COGCC and Anadarko, and a lot to be proud about. So with that, give it over to Kurt.
So Kurt Weaver with Anadarko Petroleum. I watch over the well services group. So we had I think the COGCC put the stake in the ground where they believe the well was permitted for, and we gained access to locate the well. With that, we found a rig anchor at that location, and we have a magnetometer that we use. And once we had permission to walk the property, you can see the hot spot right at the northwest corner of the house. It's there in red. And we had to convince ourselves that that was truly the spot. And so we picked up old photos from 1971 and we overlaid, what location looks like now, and determined that yes, that well was truly 35 inches from the foundation of that house.
And you kept on going.
I was asked if I could pull this off, and I reassured my boss that yes, we could do it. But not without a lot of discussion, and we had to plot out location. I had to set my pieces of equipment so everything's kind of to scale to see if there was enough room on the property for me to get everything that I needed to bring to location on there and successfully take care of the well, with in mind that I had a neighborhood surrounding me and I did not want to put anybody at risk. And after a lot of homework, we determined that, yes, we could pull it off if we could gain access to location. We go to the So we set up sound barriers to the north to kind of protect that homeowner, and a little bit on the west side. And then where the rig is sitting, we also put up sound barriers that directed the sound straight up in the air. We were also able to use some new light plants that have LED lights and really focus on what needs to be lit up so that we didn't keep the neighborhood up at night. We were able to go 24-hour ops, and within 4 days, we were at our targeted TD. And then we went to daylight operations once we started our cementing process. We had to protect the house. We looked all over the country for 9-inch equipment. There so much went on to make sure that we could get this done and get it done safely. And we had to lean on all our vendors to make this happen, but we were able to bring some dirt in. We put a mat down on the entire front yard. I challenged my group to keep every tree we could standing in the front yard, only take down the ones that we needed to, which amounted to 3 trees. I had a septic system that I had to dodge, so I roped off the septic system. That's where I set my porta potty and for my crews. But you know, the whole deal was we needed to tippy toe in, do what we needed to do, and then tippy toe out. We went to as far as we entered location. Number one, we understood what time the school bus ran. We didn't allow any work to take place as far as coming in to location until the kids were on the school bus and the school bus was out. We also knew what time they were being dropped off, and we didn't allow any of the vendors to come to location during that time frame. Our deal was we did not want to disrupt life as the neighbors knew it. When we came into location, it was as far as you can see where it says soft road closure. Everybody that came in, I wanted them to come in from the south side and park on the right side of the road. So as the mail lady or whoever needed to get through that soft road closure wasn't sitting and weaving through all the trucks on the side of the road. That's how much thought was put into every bit of this operations. It does look a little tight. We were able to get the adequate spacing that's needed as far as your enclosed flares got to be at least 75 feet away from any combustible gas, and we were able to get that footage. It came down to inches, but we were able to pull it off. We lined the whole location, and then we put our drilling mats down to help protect. And all in all, everything went like it was rode up without a hitch. My wife is the mail lady in that neighborhood and has had 4 neighbors stop her and applaud Anadarko on how well we did, that people were still able to sleep at night with windows open and couldn't tell that we were operating there. So I don't know. I think that's the record, 35 inches from a foundation, but I want to walk away and not do that one again.
Last slide we have is recapping some of the engagement. We hosted an HOA meeting in conjunction with the Oil and Gas Commission. Appreciate your attendance and support through that. We also, the following day, conducted a door-to-door to catch all the people who weren't able to attend that meeting, make sure that they had the information and expectations were set, and then hopefully we were able to meet those. We did mitigate in some of the tangible sense that Kurt mentioned, but also in facets such as hotel stays for those who are most directly impacted by the operation for the 24-hour period. The school bus schedule is a very important piece of business for us. It will also be an important consideration as we go to develop those horizontal wells in the 4th quarter. We did receive some positive feedback, as Kurt mentioned. See if this, I don't know if the audio is up. might not be. I think we can circle back to that. But essentially, the voicemail that was voicemail left by a stakeholder on our Anadarko, Colorado response line was a member who attended the HOA meeting, and she said she'd give us subjective feedback. And she lives about 5 houses to the north and did not have much of an issue at all. Really none, she claimed, with the noise. She actually hosted a party on Saturday evening. None of her attendees mentioned anything about it, and she was also a resident who slept with her windows open. Not necessarily representative of everyone's impact on this, but objective feedback from her nonetheless. And then we were very proud to get what is probably the highest bar of accolade, which is baked goods delivered to the rig crew. It's not the first time that it's happened for us, but it's really a testament to the planning and the execution of the team that conducted it for us. With that, we'd like to take any questions that you might have.
I didn't notice in the list the actual homeowner's response. But the person that owned the home within 35 inches of it, they handled all that okay?
I think that becoming aware of the existence of that wellbore was understandably a surprise. And it took an amount of time that was indicated there, more than 18 months of talking through the considerations that he and his family had. We're looking at this as a well pad. They're looking at it as their dream and their future. We believe we took that into account to the greatest degree possible, made the accommodations where they needed them. And at this moment, we're working with them through the reclamation phase, coordinating the vendors to get it done the way that they would like it to be done, taking every opportunity to see what issues or things that they notice and address those. And we're targeting being complete with regards to their interface near Thanksgiving, but we'll finish up when they say the job's done.
Any other comments or questions? Thank you all very much. Excellent.
I got one question.
Yes, sir.
Did that house have a basement?
Yes.
How, they normally over-X for a basement. How did they miss that wellbore?
I'm not exactly sure, Mr. Mayor.
I'm amazed.
We are as well. That somewhere in the construction or the platting process, this didn't come to light and get addressed appropriately is a surprise that we share as well.
Director.
Thank you, Mr. Chairman. I think Greg wanted to talk just a little bit about some of COGCC's role, and then I would like to come back, have a couple of comments to say as well.
Yes, please. And if I could have Mike come up as well and grab this. So Mike and I will just talk a little bit about the regulatory perspective and COGCC's involvement. Most of the details obviously were presented by Anadarko, and we appreciate that. Thank you. So to reiterate the background on the well, and again, this was a well that was identified during the horizontal wellbore offset evaluation process that goes on in the DJ Basin and now statewide. Because it was a plugged-in abandoned well, it did have orphan status, which meant that while Anadarko, in drilling the offset wells, horizontal wells, had responsibility to make sure that that well's integrity was up to current standards, and yet it did leave COGCC in a position to take responsibility for any E&P waste that might have been associated with that well.
We were just asked to share some of our observations as we saw it, and we looked into the background on the well. It was originally drilled in 1971 by Amoco. They drilled it to 7780, did not find any shows, did not set production strings. All they had in the hole was surface casing and open hole. They plugged it then within a couple of weeks of spud. In 1983, it was re-entered by Caribou. They deepened it by almost a couple hundred feet. They did run a long string, not a lot of evidence. They got a lot of production out of it, if any. And after much cajoling, they plugged it in January of 1987, very cold, snowy January. At the time, the surface was farmed by a tenant farmer, so this was farmland. And after the fact, after the well was plugged and abandoned, in 1982, the Mulligan Lake Estates plat was recorded within the town of Meade, and 2 years later, the home was built. As you've heard, it was evaluated with the horizontal offset policy. It was an orphan, and Anadarko submitted electronically all their forms to get authorization to re-enter to replug. This is an aerial view of what the subdivision looks like now with an approximate location.
So starting, as they discussed, they did do the magnetometer survey and then expose the well within 3 feet of the garage. In order to start their work, they did have to excavate down around that wellhead and extend the casing above ground and above the above grade, so they could put their rig above the level of the garage. The excavation that they made to perform that work was 8 feet by 12 feet by 7 feet deep, and the soil that was removed from that excavation was black, so that implicated the E&P waste issue. Approximately 30 yards of soil was removed from the excavation and was hauled off-site for disposal. COGCC did sample the excavation sidewalls and the base of the excavation, and groundwater was not encountered, and our soil sample laboratory analysis came back below Table 910 standards. And then this is a few pictures that Mike took from the work that they did on site.
I actually had 2 of these re-entry to replug operations going on at the same time. So I would stop by this one in the morning, go out to eat and check on another one, and come back in the afternoon. So I was not there full time. I observed the wellhead got placed and they started on the ground protection. And the ground protection was extensive, as they've said.
So this liner was actually placed underneath their rig mats. So 2 layers there. The rig mats support the load, but the liner really to prevent any spills.
And then the rig mats went down. They brought the rig in, elevated the floor so that it was above the roof of the garage, just like they would if they were using a snubbing unit or something. The rigs are able to work on an elevated floor fairly easily. Cement plugs were placed in accordance with the Form 6, Notice of Intent to Abandon, as reviewed and approved by COGCC. Then casing was cut, capped, backfilled, also in accordance with COGCC requirements. And this well now meets current standards, as is verified, also submitted electronically. All their third-party documentation, cement tickets, wireline tickets, and work logs and downhole logs are all submitted electronically and on our files. The landscaper is in process. As they said, it may take them a little bit to get everything growing again, but as required by COGCC, the remediation is responsibility of the operator.
That's all from staff, director.
Actually, in the interest of time, I think these guys have covered it, but it was a good collaborative operation between the agency and Anadarko.
This project, this property, I'm assuming, would not meet urban mitigation requirement. threshold?
Actually don't know how the density of the house is within the well. I do know that this wouldn't meet current setback standards.
I think it would be a UMA as well.
That increases my level of confidence. Thank you. Thank you, gentlemen, for an excellent presentation and for some really, really good work.
Thank you.
I suppose this responds to Commissioner Allward's encouragement to do the right thing, do the best thing.
How quickly they responded.
How quickly they respond. Okay, next item then, Ms. Murphy.
Chairman, I believe it's a presentation on 1041 areas and activities of state interest. And I believe Ms. Green is here on behalf of Eagle County and Ms. Jost on behalf of COGA.
Welcome, ladies. You may proceed.
Did you want to go first? No, how are you? Okay. I'm Barbara Green, and I'm with the law firm of Sullivan Green CV.
Ms.
And-
Green, sorry, will you pull that microphone? There you go. Thank you.
Is this better? Okay. It sounds booming to me, but the reason I'm here is I'm here on behalf of the Eagle County Commissioners. And they have an idea that we've bounced a little bit off of the staff over the course of the past year. But we wanted to come to you all and broach the topic. So this is purely informational. I'm also here if you have preliminary questions, but I'm sure you'll have more questions down the road. The reason why Eagle County is coming to you is because they need to update their oil and gas regulations. And in considering the lay of the land, looking at the citizen initiatives that happened a year or so ago, looking at the governor's task force, taking into account all of the litigation that's gone on about the relationship between local governments and the state and how they fit together, the commissioners were searching through their own authority. And you all probably are fully aware that county governments only have the authority that's granted to them by the state to regulate. And their authority typically is exercised through their zoning authority, their subdivision authority, and something called 1041. 1041 is an act that was passed back in 1974. And the 1041 comes from the name of the House bill. I remember when I first started practicing law and a county commissioner asked me whether I believed in 1041. I really had no idea, and I'm searching through the statute trying to find it. But it's actually in 24-65.1-101. And I have a brief summary here for you that I can hand out when we're finished. But the reason why the commissioners wanted to talk to you is because unlike other land use regulatory authority at the local level that can be used to regulate oil and gas development, 1041 requires that the Oil and Gas Conservation Commission, quote, identify, close quote, an area of oil and gas operations. And so before the county wanted to proceed exploring 1041 as its source of regulatory authority, they wanted to begin discussions with the COGCC. That's why I'm here now. I'd like to just give you a little bit of the reasons why they feel like they need to update their regulations. Right now, oil and gas in Eagle County is non-existent in terms of any active permits, but they've been getting a lot of requests from their public. As you know, this relationship between state and local is of heightened importance right now. And so in going through their regulations in response to these concerns, they looked at their special use permit regulations, and they're just not really designed for oil and gas. They're the old-fashioned special use permit regulations that apply to all extraction industries. And they have a lot of prescriptive standards that frankly raise some kind of preemption concerns because they dictate certain ways that an activity has to be carried out rather than setting performance standards. So the county decided it needed to update its regulations. So that's how this all came about and why we're here today. But we also have the luxury of no active operators right now. 1041 itself is a really interesting statute because it was, like I said, it was passed in 1974. And when you go back and look at the legislative history, it was clearly an attempt to take into account what was then a very rapidly growing state. Some of the percentage increase in population is mirroring what we're seeing now, and a concern that there was a lot of unregulated stuff going on. And because of the lack of regulation, we had residential properties being developed in geologic hazard areas, in oil and gas resource areas, in mineral resource areas, in wildlife habitat areas without any controls. So the state, the legislation was designed, it was a carrot and a stick. There was money back then where a local government could get money from the federal and state government to map these areas of concern, and then in exchange draft their own regulations. The statute started out with the Land Use Commission itself actually regulating local governments. That didn't get very far at all. By the time the bill was finally enacted, it was clear that we're a local control state, and there was no way that Colorado was going to have something like Florida or Oregon, where you actually have a state land use board that regulated anybody. So the statute still says areas of state interest and activities of state interest. And there's a menu there of 13 or 14 areas and activities of state interest from which a local government can choose. You can choose to regulate a water project. You can choose to regulate a wildlife habitat area, a mineral resource area, for example. The development of a nuclear detonation site, which is an also very interesting part of the statute. Just in case local governments want to regulate nuclear detonation sites, they can under 1041. So out of this, counties really like this. I think there are 32 counties and municipal governments in the state that regulate something under 1041. Counties really like it because, like I said, it's a clear grant of statutory authority. So the structure of 1041, unlike some of the other areas of state interest, actually do still have state involvement, and that would be you, in the identification of the area. Once the COGCC identifies an area of oil and gas development, then the local government regulates that area. And the statute says that in an area of oil and gas resources that's been identified and designated by the local government, that again, going back to protecting the resource, the resource is really given preference. So land uses that would interfere with oil and gas extraction are not allowed unless an odd portion of the statute, unless the surface use, the other use, the non-oil and gas use, somehow had a higher economic value than the value of the minerals. And that showing for someone to actually come in and interfere with the extraction of oil and gas would require a hearing in front of the local board of county commissioners that would show that through technical evidence and legal evidence that somehow the value of the surface use was greater than the value of the resource. In Eagle County, and then let me back up for a second. Then the local government enacts its regulations and goes forth to regulate. The county's been thinking a lot about this. We've had a couple brainstorming sessions where it's never been done before. No one's ever approached this commission and asked you to identify an area. So there's no clear path forward about how that would happen. And we would be working with Mike King and Matt Lepore to try to figure out that sort of structure to propose to you for how that would happen. The commissioners would very much like you to consider that this be done through an intergovernmental agreement like the IGA you have with Gunnison County, because that seems to have been very successful. But we're open to all kinds of ideas and discussions on this. Because this is so preliminary, the county has not yet had any of its own stakeholder meetings. The county is very aggressive when it comes to public involvement. It's one of the most active counties. You all know where it is, like Vail's right in the middle of Eagle County with Steamboat and Route County to the north. We have Pitkin County to the south, Garfield County to the west, and Summit County to the east. So it's a very, very active, very publicly involved part of the state. Excuse me. But before they engaged their public and began any kind of public process, they just wanted to have this informational session with you and just let you know that we're out there and that we're thinking of taking this approach. If we decide that it doesn't make sense to engage the Oil and Gas Conservation Commission in identifying an oil and gas area, then the county will go ahead through its other land use authorities and adopt better oil and gas regulations that are much more focused on the current law and the state of the relationship between the local regulatory body and the state. But if you are interested in moving forward, then we will be coming back with a formal request for identification. The area in Eagle County that is most likely to be designated by the county commissioners as an oil and gas resource area that they would request you to identify is about 80% federal land. The other 20% is zoned resource, which is a minimum 30-acre lot size in Eagle County. It's primarily what you all would know as your agricultural zone. And then the private lands that are within that area are zoned as, those are the private lands. The federal lands are zoned federal because local governments can't really zone federal lands. You can regulate the impacts of environmental things, the environmental impacts of private land uses on federal lands, but you cannot regulate federal lands by zoning them. No local government could go to a federal land manager and say, we want this to be housing. We want this to be agriculture. We want this to be open space. Yet you can have regulations that address the environmental impact of private uses on federal lands, subject to all the normal preemption analysis. So in Eagle County, they recognize they can't zone federal lands, so they call them federal lands. And in case any of those lands go from federal ownership into private ownership, they automatically go into an 80-acre minimum lot size zoning. So the odds of any kind of intense or dense development occurring in the areas that look like they'd be oil and gas areas are pretty slim in Eagle County. Let me just see if there's anything else I wanted to mention to you. There are 8 leases that we were able to find on about 13,000 acres of federal land in Eagle County. And from our review of your own website, we were unable to find any active wells now. So that's the lay of the land. That is, as I said, for informational purposes only. The county commissioners are really excited about this idea because they see it as an opportunity to work together with the COGCC, and they really like the fact that the statute itself actually sets up a working relationship between the two entities. So that's my presentation, and I'd be happy to answer questions and or you can hear from Jamie and COGA's interests.
If it's okay with my colleagues, I'd like to hear from Ms. Jost before we interrogate you.
Okay. All right, thank you. Thank you, Barbara. Good morning. My name is Jamie Jost, the managing partner of Burleson LLP's Denver office here in Colorado, and I'm here to speak on behalf of the Colorado Oil and Gas Association. COGA does appreciate the opportunity to provide comment to Eagle County's presentation on the Areas and Activities of State Interest Act and how Eagle County is reviewing and interpreting the Act and potentially considering utilizing the Act to isolate the development of mineral resources and enact oil and gas regulations governing an area of mineral resources within its jurisdictional boundaries. Before I go into several points, I do think it's imperative that this commission is aware that Eagle County informed COGA about its consideration of the 1041 designation last Monday, October 19th, 2015. And this is despite COGA's numerous attempts to outreach to Eagle County since August of 2014. This is a complex, untested theory of mineral resource isolation, and it was only disclosed again 1 week prior to the hearing. So we do appreciate the opportunity to comment on this and do look forward, I'm assuming, for further discussions in the future. It is COGA's understanding that the commission will not be voting, analyzing, or providing direction to Eagle County at this hearing, and that this unique allowance of being given an unnoticed presentation matter by Eagle County is just purely that, is informational. So at this point in time, COGA cannot and will not provide a detailed comments to Eagle County's potential pursuit of a 1041 designation. Historically, however, COGA has not supported the use of 1041 authority being applied to oil and gas development, and as it has been viewed as an attempt to circumvent established Colorado case law providing the exclusive jurisdiction over technical and operational aspects of oil and gas development to this commission only. The COGCC has recently asserted this exclusive jurisdiction argument in litigation that is currently pending in front of the Colorado Supreme Court. So notwithstanding my foregoing statements, COGA does want to provide a few high-level comments in light of Eagle County's interpretation and explanation of the Areas and Activities of State Interest Act. First off, the Act provides specific criteria for the administration of areas of state interest, and Ms. Green is correct in that a local government can designate mineral resource areas as identified and approved by this commission. However, such areas can only be approved through a detailed analysis that will utilize technical, operational, and economic factors, as well as taking into account, and this is a quote from the statute, the intensity of current or foreseeable development pressures. At this point in time, and I believe as Ms. Green just said, it's my understanding there are no active wells within Eagle County. And actually the staff report published today noted that as well. And I think Eagle County is actually missing from some of the lists that are on the staff report because there are no active wells in Eagle County. So further, it is unknown at this point in time what potential surface development may be proposed on the areas that Eagle County may want to designate as an area of state interest. Eagle County, at least with the information known today, is not facing intense or foreseeable development pressures that must be considered as part of the identification and designated process for an area of state interest. Further, the Act provides that mineral resource areas designated as areas of state interest shall be protected and administered in such a manner as to permit the extraction and exploration of minerals therefrom, unless extraction and exploration would cause significant danger to public health and safety. And this is verbatim from the Areas and Activities of State Interest Act. As we're all aware, there are numerous groups within the state of Colorado asserting, without technical, scientific, or peer-reviewed evidence, that oil and gas development is a danger to public health and safety. COGA would need assurances from the commission that it would exert its exclusive jurisdiction over oil and gas development to ensure that the development of minerals would be utilized from any identified and designated areas and not allowed to be subject to a de facto ban or moratorium due to unfounded allegations or positions relating to the impact of oil and gas development. Additionally, the Act provides that if the local government having jurisdiction, after weighing sufficient technical or other evidence, finds that the economic value of the minerals present therein is less than the value of another existing or requested use, such other use should be given preference. However, other uses which would not interfere with the extraction or exploration of minerals may be permitted in the areas of state interest. Another quote from the Act. The reason I bring this up, because again, as we're all aware, there are numerous areas of the state that challenge the development of oil and gas. At this point in time, an operator should not be forced to be subject to a challenge of whether another activity trumps oil and gas development on the basis of an economic evaluation. Local governments are uniquely constrained in designating an area of oil and gas activity by the requirement for commission approval. As Ms. Green correctly pointed out, there's no commission rules or procedures outlining any such identification and how that approval would occur. It could be via an application with a corresponding order. It could be via rulemaking. It could be via a publicly approved after hearing intergovernmental agreement or other process. The commission would need to carefully review the Areas and Activities of State Interest Act, the Oil and Gas Conservation Act, and the Administrative Procedure Act, as well as current Colorado case law, to determine how this 1041 designated process could actually occur. Further, any and all details of local government's companion regulations, both inside and outside a 1041 designation area, would need to be carefully reviewed and retained by the jurisdiction of this commission. Overall, the 1041 concept only makes sense when you're dealing with the topic of enabling a local government to constrain surface development from precluding future oil and gas development, not as a way to regulate oil and gas development, other than by providing an expedited land use approval to well sites in a 1041 area. basically, without further discussions on this with the commission and with Eagle County, COGA is concerned that the intent of this may be an end run around current case law under which the COGCC does have exclusive jurisdiction over the technical and operational aspects of oil and gas development. The purpose of a 1041 designation cannot be to escape preemption. As stated earlier, COGA does appreciate the opportunity to provide comments on this matter, and we've pointed out several high-level concerns and requests that the Commission forego any decision or direction on this issue until all parties have had the opportunity to better understand Eagle County's position for the need to potentially evaluate an area of activity of state interest. COGA will continue its outreach to Eagle County and Ms. Green, and we will engage in detailed discussions in this 1041 proposal designation and process. Our mission is to ensure that responsible development of our state's valuable natural resources does occur in accordance with the applicable laws and processes set forth by this commission. At this point in time, COGA cannot take a position on Eagle County's potential 1041 designation without more information and without an assurance that any designation may meet the purpose, the need, and the intent of the Areas and Activities of State Interest Act. Again, I know that was very long-winded, but we really do appreciate the opportunity to have this discussion and put these points forth today, because this is a very unique presentation that's been given to you that would require a lot of substantial consideration before it would be moving forward. Thank you very much.
Thank you, Ms. Jost. Any questions? If I understand what you're saying, Eagle County would like to designate 10,000 acres and get the Colorado Oil and Gas Commission to agree to that designation for oil and gas development. And then all other acreage within Eagle County would be off limits to any oil and gas activity.
No, I don't, excuse me, I don't think that's the way the county's thinking. I guess I'd like to just, on behalf of my client, express a little bit of concern that they're being painted as trying to do an end run around the existing law. We're going to be arguing that on December 9th, but it has nothing to do with a grant of statutory authority that clearly lays out the authority of a county to regulate oil and gas activities. So I'd just like to say that. I would be not doing my job on behalf of my wonderful commissioners to let that go unaddressed, since this is all on the record. Eagle County would probably, and again, as Ms. Jost mentioned, we made a courtesy call to COGA last week, even before we came to you. And you know we haven't come to you. We went to them before you. And back in December, we also met with Ken Stolen to broach this idea with him too. Just, it's so preliminary. I just want to emphasize that. So in the preliminary thinking, the county would probably use a regulatory approach for the identified area of oil and gas development, that an expedited process in it. Because under their normal regulations that are in effect right now, as you would know, the regulations require both commission review and hearing, as well as county commissioner review and hearing. So what they're thinking about is in this area where it looks like oil and gas resources are most likely to be developed, that would be subject to more expedited review that would privilege oil and gas development in that area where it's more likely to occur. But I believe the county commissioners are leaning towards still allowing it everywhere. I'm not even sure how they couldn't allow it everywhere, and they would probably keep their existing regulations in place, or they would amend those to be more in keeping with the law. I'd also need to mention that Eagle County's been using 1041 as a statutory authority for regulation since 1979, and they've actually been involved in litigation in it too. So they're very comfortable with it, and I find it works very well, especially when they're dealing with so much federal land. It's been a good grant of specific statutory authority for them in lieu of the more general zoning authority that most local governments use to regulate oil and gas.
A quick sidebar. In your legal opinion, can a county tell me what color to paint my barn using their 1041 authority?
Could a county tell you what color to paint your barn using 1041? If you were in a wildlife habitat area that was subject to local government regulations. And during the course of the hearings, you have to have hearings and evidence and testimony to adopt 1041 regulations. I suppose if there were evidence on the record that somehow your chartreuse barn was causing an impact to wildlife, yes, I think they could.
I tend to agree with you. Commissioners, any other comments or questions? Interesting Commissioner Allward.
Thank you, Mr. Chair. This is interesting. And being a non-attorney my entire life.
Good for you.
In this weighing the economic value of other activities, I pulled up legislation, which means I don't, even though I can read it, I don't initially understand it. But I don't see any consideration to time frames in this. So I'm wondering, in your interpretation, if oil and gas economic value would be extracted over 30 years, but a ski resort would be there for 100 years, how do you weigh economic benefit?
Well, first of all, the way I interpret it, I think there's a clear preference to protect the resource by identifying an oil and gas resource area. So I think any local government interpretation that would fall on the other side of that would be very unlikely to be upheld by the courts, especially in light of more general preemption law that would still apply. So I believe that the way it reads is that if the local government having jurisdiction, after weighing sufficient technical or other evidence, finds that the economic value of minerals present therein is less than the value of another existing or requested use, such other use would be given preference. So it applies both to existing and future uses. So I think it goes on to say other uses which would not interfere with the extraction and exploration of minerals may be permitted in areas of state interest. So the way we've been looking at it, first of all, the burden of proof would be on anybody who came in there and said, you know what, I want to pave this over. I'm not going to allow any oil and gas development because what I'm going to do, my nuclear detonation site, is of a higher economic value than the oil and gas resources here. The burden of proof would be on that person making that assertion, and it would be a heavy burden of proof. But that would be one thing that the regulations would spell out. What the commissioners are thinking of right now on that point is for if anybody were to come in there now, and remember how it's zoned. The only thing you can do there now is agriculture or oil or gravel, oil and gas right now. It's zoned for very large lots. And about 20% of it is private, the rest is federal anyway. And that test couldn't apply on federal land because that test would run afoul of not being able to actually, you can't tell the federal land manager how to use the surface. So it would only apply to private land. And I think what we're looking at is exploring a way to have anybody now who wanted to do, let's say it's an outfitter or something like that, which would be maybe one of the uses that might happen there, they'd have to come into the county before they could go through the normal land use process, which is open to them right now, where they could come in and get a special use permit or some other approval to proceed. If it were an oil and gas resource area, first they'd have to come in and show that it would not cause interference with the oil and gas resource. So it's one step more protection actually for the resource that exists right now. So I think that all of that would have to be worked out in the regulatory structure, and it would require hearing and evidence and so forth. But the likelihood of you ever having an activity where they could actually prove the economic value is greater than the minerals underneath would be a very difficult showing and probably an unlikely occurrence. Does that help?
Yeah.
Okay.
Yeah, I think I just want to add one thing, if I may. I agree with Ms. Green's last statement that, that another industry coming in and potentially proving that the economic value over the life of the minerals underlying that area is going to be a hard burden. And I think that's one point of agreement that we can say today. And really just to echo her, it's unknown how this process would work, Commissioner Allward, because Eagle County hasn't gone through the mineral resources area designation for an area and activity of state interest. to put in regulations, how an economic value may be determined or what evidence may be utilized. That would all involve public notice, public hearing, discussions, negotiations with the county, just like industry does in every other county, municipality, jurisdiction in our state. So I think it's a hard answer to say, true and fast, is everything going to be considered for an economic evaluation? The answer would be yes. What's allowed to be considered would be another story.
I forgot to mention too, in response to your question, that right now in the greater Wattenberg area, you have the whole idea of OGOAs, but that does oil and gas operation areas. That doesn't apply outside of that. So we were kind of thinking that it would be similar to that, where for a developer, a non-oil and gas activity were to come into that area that had been designated. In order to show that you weren't going to interfere with the oil and gas resource, you'd have to show how your development and the oil and gas resource would work together right off the bat. That would be part of your showing, and then you could go through the county's regular regulations. So we put another hurdle in place of a normal development before they could develop.
Commissioner King.
Thank you, Mr. Chairman. When Ms. Green brought this to my attention, a couple of things jumped out. I mean, clearly we're still struggling with the relationship between this body and local governments and where the jurisdiction begins and ends. And yes, we've got a question going in front of the Supreme Court here in December, but it's not all the questions, right? I mean, we may not get an answer out of that decision if it's limited strictly to moratorium, duration, and bans. It still won't resolve the broader issue about where that line stops between land use control versus oil and gas development. And so when Ms. Green brought this to my attention, I mean, clearly the act envisions in some manner oil and gas fitting into 1041. I can tell you I can't quite get my brain around that, but that act actually came after the enabling provision that says notwithstanding any other provision, the Oil and Gas Conservation Commission shall regulate oil and gas. And then they promulgated 1041 after that and clearly envisioned that there's some role. So I guess Ms. Jost said we're not here to provide direction, but I don't take direction very well. So I'm going to provide direction. I encourage you to keep talking. I encourage you to explore this, whether anything comes of it, whether we can work through these particulars. This is an ongoing, difficult situation, this relationship between the state, local governments. And if this is a potential toolbox where things come out of this, even if it's not full implementation of 1041, but things come out of this that will help us better refine those relationships and make this better for the state of Colorado, I'd encourage you to do that. And I think that this is a productive discussion. Whether we get to full 1041 implementation or not, we should explore it, and we have an obligation to continue to explore this and any other tool that will help us resolve that conflict that currently exists.
That sounds like good advice. Not that I take advice either, but. Commissioner Holton.
The only question I'd have is being on the Weld County Planning Commission. We did 1041 stuff, but the Planning Commission was final say. I mean, it's very difficult to overturn that. So is that part of the statute, or is that just part of what Weld County has adopted?
I want to answer you directly, so I need to say I am not the Weld County attorney. I am not advising Weld County. You will get different advice from your Weld County attorney. But one of my concerns has always been when 1041 is implemented by jurisdictions, whether they're municipal governments or counties, and they actually have the Planning Commission in there at all, because the statute talks about the permit authority. In counties where they have to rely on their planning commission because they really don't have a planning staff, it's a lot better to make the planning commission like a referral agency, like any other referral agency. But to put the final decision making in the hands of the planning commission under 1041, excuse me, Weld County, I think is a problem.
Well, and Weld County's got a big planning office, but they turn over that responsibility to the planning commission. So I'd really be questioning whether or not that's in the statute or how that's being handled.
It's not in the statute. There's no mention of the planning commission
It's
at
in
all.
front of the county commission whatsoever.
Well,
It's hard to overturn. Once the planning commission Believe me, I was there when we did.
Well, now, they may have gotten around it because the statute refers to the permit authority, and they may have gone through a hearing where they delegated to the planning commission the role of the permit authority. That would be, if they did it that way, I think that would be consistent with the statute, because the statute talks about the permit authority. But to have a couple layers in there is probably not a good idea.
So you're envisioning just the wellbores and the operations themselves, or is that going to include pipelines?
They haven't really talked about that. Right now, under their existing regulations, pipelines would require a special use permit.
Okay.
Okay. Any other comments or discussion? I think we're encouraging you to continue these discussions because there may well be some really beneficial results.
And the commissioners also asked me in thanking you to let you know that if this looks to you like it's more of a headache than you're wanting to take on, they'll just go ahead, business as usual, but they thought this might be a good idea.
The other thing I'd like to see is if you guys could make this same presentation to CCI.
Oh, yeah.
To see what kind of
sure.
comments they come back with.
Sure. That'd be
Okay. Does staff have any comment?
No, sir.
No comment.
Thank you very much.
Thank you very much. Our next item, we're moving into the general hearing matters. First is docket 151000564 Cub Creek Energy. So, Ms. Murphy, is
I do have a question for you, Chairman. It's at your discretion to change the proposed agenda, and if people are hungry, we could take an early lunch and have our hearing matters in the afternoon.
people being?
Well, you, sir, and your colleagues.
I saw Mr. Willis earlier, but, oh, there he is. Mr. Willis, would it be too terrible for you if we went ahead and took a lunch break now, and then we did your matter?
Very differential, and I know the other party probably is, so whatever you want.
Colleagues, eat now and pay the price later? Okay, and we'll do that. We will go to lunch now. During lunch, we also have an executive session.
What time would you like to reconvene after lunch? So everybody is ready and prepared for you.
What do we need, 45 minutes or?
Yes.
12:30.
A quad till 1, 12:45, okay? Okay, we'll reconvene at 12:45. Thank you all very much. So, Mr. Matter, can you give us?
You need a motion to enter executive session, whereupon we will discuss the areas and activities of State Interests Act 1041, timing limitations to pooling orders and the Commission's authority to establish the same, and the legal arguments raised in this afternoon's disputed hearing matters, which are Cub Creek versus Kerr-McGee and RWL versus Synergy.
So moved.
Second.
We have a motion and a second to go into executive session to discuss the matters that were listed. All those in favor indicate by saying aye.
Aye.
Opposed, same sign. We will recess for an executive session and lunch reconvene at 12:45. I think we will reconvene. It's okay with Enrique. And we will take up, we will consider a motion to
So moved. Second.
get out of executive session.
What was the motion?
The motion was to get out of executive session.
So it is.
And it really got a motion and second. We're voting.
We have discussion first? No discussion?
We are out of executive session.
So during the executive session, we discussed the commission's authority under the Areas and Activities of State Interests Act, the legal issues in the RWL Synergy and Cub Creek versus Kerr-McGee matters, and also timing limitations on pooling orders. And we did so pursuant to the Open Meetings Act 24-64023A2, which allows the commission to enter into executive session for conflicts with an attorney representing the commission to discuss specific disputes and legal issues. No decisions were made.
But there was some dispute.
There are plenty.
Okay, thank you very much. Docket 15100000564. And what should I do?
I would turn this over to Hearing Officer Jen Bach to let her take us through this protested application.
Ms. Bach, I'm turning this over to you.
Okay, thank you. Good afternoon, commissioners. Is it on?
Press hold.
Let's go.
Okay. Both instructions worked. All right. Good afternoon, commissioners. I'm Jennifer Bach, hearings officer. This matter, docket number 1510-00564, comes before the commission upon Cub Creek's application for an order to pool all interests in a 320-acre drilling and spacing unit and to subject non-consenting interests to cost recovery. As you'll remember, the commission approved Cub Creek's spacing unit for the same lands at the commission's last hearing in September over the objection of Kerr-McGee. In this matter before you today, Kerr-McGee timely protested the pooling application. A pre-hearing conference was held, and you have in your packets a staff recommendation for approval of the application. Each party has 45 minutes to present its case, and Chairman Compton has a schedule in front of him, as do the parties.
Oh, he does. Okay, so determination of whether any commission members have a conflict of interest. I'm not seeing much activity there, so I'm assuming there is no declared conflict of interest. Introduction of the matter and pre-hearing order. Hearing officer recommendation. I think we did that. She had 5 minutes, only used 2. That's very commendable. Kerr-McGee's opening statement. Kerr-McGee.
Chairman?
Ma'am.
I believe it's Cub Creek.
I'm sorry. You're absolutely right. I thank you very much. Cub Creek. My apologies.
Thank you, Chairman. That's fine. I appreciate that. I wanted to let you know that I did have a preliminary discussion with Mr. Wozniak. It was agreed that we would stipulate to admission of expertise of the witnesses in this matter, as well as exhibits which have been provided to each party and exchanged through pre-hearing statement. I do anticipate on calling a couple of witnesses, and I know Kerr-McGee also has some witnesses anticipated, so I'm wondering at some time during the process you may want to swear all of them to expedite the swearing-in process.
I wonder if council could do that like right now.
Sure. Everybody who's going to be a witness, please raise your right hand. Swear or affirm under penalty of perjury that the testimony you're about to provide today is truthful and accurate. Thank you.
Very well.
Thank you. Good afternoon, Mr. Chairman, Commissioners. My name is Rob Willis, and I represent Cub Creek Energy in this proceeding. Cub Creek is a registered operator with the Commission whose principals have decades of experience in the oil and gas industry as both operator and non-operator. As you heard this past September in Gunnison, Cub Creek owns substantial leasehold interests underlying the north half of Section 12, 4 North, 68 West, which include working interest and operating rights for the Codell Niobrara Formation. Testimony and exhibits from Cub Creek will show that it is conformed to relevant provisions of the Act and COGCC rules by serving the application and associated notice of hearing on those persons and parties who own any interest in the, in those mineral tracts within the application lands to be pooled, except those owners of overriding interests. Cub Creek requests the commission enter its order pooling all interest in the approximate 320-acre drilling and spacing unit established for the application lands pursuant to order number 407-1416 for the development and operation of the Codell Niobrara Formation. Testimony will demonstrate that on September 21st, 2015, which is more than 35 days prior to this hearing today, Cub Creek served well proposals for the drilling of 9 planned horizontal wells. I refer to them as the Vale wells on Kerr McGee. The well proposals for each Vale well included the following information as required by Rule 530. The location and objective depth of the well, including surface location, target depth, top and bottom of perforations, and total measured depth. Estimated drilling and completion costs of the well via an AFE which was attached, as well as an estimated range of time in which each well would be, in which the well would be spud. As of today's hearing, Cub Creek has been unable to secure letters of participation for the drilling and completion of the Vale wells from Kerr McGee. Cub Creek will present testimony in support of the amended application through 2 witnesses today, Scott Bailey, Vice President of Land and Business Development for Cub Creek, and Andy Peterson, who's a consulting engineer to Cub Creek. Following the presentation of evidence today, Cub Creek will request the commission enter its order pooling all interests in this unit area established for the application lands for the development and operation of the Codell Niobrara Formation, and authorize Cub Creek to recover costs and risk penalties as permitted by the Act against Kerr McGee's interests by declaring those interests owned by a non-consenting owner. Thank you.
Okay. Mr. Wozniak.
Good afternoon, members of the commission. Mr. Chairman, thank you very much for allowing us to be here. My name is Mike Wozniak. I'm here with my co-counsel, Jill Fulcher, and we're here on behalf of Kerr McGee. Listening to Mr. Willis's opening, I'm going to tell you that from my view, this is anything but a standard pooling application. It's much different, and I think it's important that as part of our opening, and I'll spend a little bit more time on this on closing, that we talk a little bit about our statutory requirements in a pooling application. As Director King asked last month when we were in Gunnison, which by the way, we did ask to consolidate these matters, but staff denied the consolidation request, so we're sorry that we're taking your time up again. But under 30-60-116-6, there are at least 2 and possibly 3 elements that the applicant must prove in order to get a pooling application approved. The first one is that the terms that they're going to propose need to be just and reasonable. So when you're doing your deliberations a little bit later, I'm going to ask you to decide whether the terms that you hear today are just and reasonable. And the second issue, they must prove, and again, the burden is on Cub Creek, to prove that they can conduct these operations without unnecessary expense. So they have those 2 elements they need to prove, and those are pretty standard. The other issue, though, that's really interesting and very honestly complicated under Colorado law is a trespass issue. Now, I will spend some time on closing talking about that because that's mainly argument. But the one thing I do want to point out to you all is that in 30-34-60-116, what it says is that operations that are conducted on a tract within the pooling unit will be deemed to be conducted on each tract. The statute goes on to say that production will be deemed to occur on each tract. What the statute does not say is that operations may be drilled, produced, completed from a tract in which an applicant owns no interest. And that's what we have here. The evidence will show that Kerr-McGee owns 100% of the leasehold in the northwest quarter of Section 12. That is the area in which Cub Creek proposes to locate its surface facilities, to drill the well, to complete the well, and to produce the well. So our evidence will show today that application of the statute is not permissible to allow this operation to occur on our leasehold. So what we think our evidence today will show that it's not just unreasonable to pool where Cub Creek, as a minority working interest owner, locates 100% of its facilities on Kerr-McGee's leasehold interest, and in our view, trespasses through those minerals, produces them over Kerr-McGee's objection. Now, there's been a lot of pooling applications, but I want you all to think back, and how many of those pooling applications have located and produced on a non-participating party's interest over their objection? Sure, there's been a lot of implied consents, but a definition of trespass right out of Williams and Myers, which is the oil and gas treatise, says if you bottom hole your well on someone else's land, that's trespass. So the question that you have to face today is, do your pooling statutes trump common law trespass? And I'll submit to you that I'll discuss on closing that they do not. So that's one issue as to trespass. The other issue is it just unreasonable to pool Kerr-McGee unless the applicant can show that they can conduct these operations without unnecessary expense? Our evidence today will show that at best, our rate of return participating in these wells would be zero, and more likely would be less than zero, which means that these are uneconomic proposals. Cub Creek's AFEs propose to spend between $28 and $30 million in January, February, and March of 2016. We'll have evidence today that shows that that will be less than a zero rate of return. And so the question is it just unreasonable, again, under these terms, to pool Kerr-McGee, the 100% working interest owner in the Northwest Quarter? So our position is that the Oil and Gas Conservation Act does not abrogate trespass in Colorado, and that at closing time, we will ask you to consider my arguments on that basis. We'll have two witnesses today. Shay Kaufman will testify on some land issues, and Dave Schnabel will testify with respect to the economic issues. And at the close of our application, we request that you deny the pooling application number 1 and deny the request to penalize Kerr-McGee for Cub Creek's operations on Kerr-McGee's leasehold. Thank you.
May I ask you a question, Counselor?
Sure.
Technically, where is the downhole location in a horizontal well?
Well, the downhole location on a horizontal well is, the proposal in this case is to produce along the entire length of that horizontal well, including underlying Kerr-McGee's minerals. So I would say it's the whole length of the horizontal
So
lateral.
Each segment.
Yes, sir.
Thank you.
Which,
Commissioner Benton.
can I ask, so I think what I heard you say was that the trespass deals with where you bottom the well.
Mhm.
Is that correct?
It's where you produce the well from. I mean, the traditional law was based upon vertical wells. So of course, the cases talk about where the well bottoms as though it's a vertical well. If you drill a vertical well and it drifts off your leasehold onto your neighbor's leasehold, it bottoms on the neighbor's leasehold, that's clearly a trespass. Our position is if you complete and frack and produce all along the wellbore, that is a trespass unless you own those minerals, absent consent of the party who owns that leasehold.
Thank you.
I'm kind of looking at my experts.
Well, I have, It's an interesting point, but I think I'd like to hear what both sides have to say, because it's an interesting way to take a look at this. It sort of goes back to why we pool in the first place. So I want to hear what they have to say.
Very good.
If I could start then by calling Mr. Bailey, Scott Bailey.
Okay.
Scott, would you please give your name to the commission and let them know what you do for a living?
My name is Scott Bailey, and I work with Cub Creek Energy, and my title there is Vice President of Land and Business Development.
And could you briefly describe your experience working the DJ Basin?
I've worked almost exclusively at DJ Basin for the past 3 years. Before that, I'd worked other parts of the country, including some in the DJ Basin, but exclusively the past 3 years working for Texas Energy and now with Cub Creek.
How much total time have you been working as a petroleum landman?
Over 30 years.
Okay. And you're familiar with the COGCC rules and regulations?
I am.
Okay. You've caused a pooling application to be filed, which is subject to this hearing today. It's for the development and operation of the north half of Section 12 of 4 North and 68 West for the Codell Niobrara Formation. Could you briefly describe that application?
The application is to allow for the pooling of the 320 acres that you described, the north half of Section 12, to allow for the drilling of 9 wells that we proposed to Kerr-McGee specifically.
And have you been able to talk with Kerr-McGee about your plans and been able to come to any kind of agreement with regards to how these minerals are to be developed?
We've had a lot of discussions over the past several months with Kerr-McGee, obviously, and those discussions have not resolved into a agreement on how they should be developed. Kerr-McGee was not ready to put together a development plan within the near future that was going to be satisfactory to Cub Creek, so we proceeded with the spacing and now the pooling application.
Now, of course, I prepared a PowerPoint presentation with you, and I kind of mowed right over the first couple of slides. So what is this first slide?
First slide just is a general area view of the DJ Basin that shows specifically the 320 acre, which are the application lands.
Okay. And the next slide.
It's more specific slide that shows the general location of the wells that we're planning on drilling, the 9 wells, and the application lands, specifically the north half of Section 12.
Now, I've referred to these wells as the Vail wells in my opening. Have you named them the Vail wells with some kind of chronologic order or sense to the project?
Yeah, the surface location that we have selected for this project, which is outside of the town of Johnstown, which is a big, fairly undeveloped 160-acre tract, is owned by the mineral owner and surface owner, Mr. Vail. And we have named the wells after Mr. Vail, and there's 9 wells, a mixture of Codell and Niobrara wells, horizontal, 1 mile horizontal wells.
We'll move on to Exhibit 3. What is this exhibit?
Just so specifically that Kerr-McGee is a party that we are applying for pooling to be applicable to their interests at this point in time, because they have failed to elect within the 35-day statutory period.
Okay. Let's go to slide 4. Slide 4 is what?
That's the letter that was sent to Kerr-McGee specifically with the well, proposing the wells. There was a well for each letter, a letter for each well that was sent to Kerr-McGee. This is specific as to the number 1 well that was sent to Kerr-McGee. Identical wells were sent essentially for every well that was proposed to Kerr-McGee, obviously with the information, the locations, and the cost slightly changed for each well to depending if it was Codell or Niobrara, and obviously the location of the wells.
And this particular document, it includes description of the well itself, is that right? And then the target formation, that there's a drilling and spacing unit involved, which has been approved by the commission?
Correct, and it goes on to say specifically the surface location, the target formations, and there's some more specific attachments, obviously, to the letter that gave you more detail.
Okay, and it talks about an anticipated spud date?
Correct. We're looking at probably first quarter of next year for spud.
Okay, and this next slide, slide 5, is the second page of that election letter, is that right?
That's correct.
Okay. And is there anything you want to bring out in that slide at all, or is it just consistent with your testimony so far?
It's consistent with the testimony. Again, just referencing specifically the attachments, the AFE and the survey plat. We have even provided a directional drilling plan that was attached for every one of the wells.
Now, this exhibit looks like it's a microfilm here, but it's better obviously when you present it. What is that?
That's the first page to the AFE that we sent to Kerr-McGee specifically. I think that's the drilling, sets forth the drilling cost of the AFE.
And that's in 2-page form?
Correct.
I think I missed the last one. Go to previous. So that's the second page.
The second page, which shows a total well cost of about $3.1 million.
Okay. There's a slight deviation for each well, is that right? Because the total depths are different?
The Codell and Niobrara wells are different. But among the Codells, for the most part, they're the same cost, and same with the Niobrara.
And these are actual costs, or are they estimated costs?
So it's estimated costs as best we can do at this point in time based on our current thoughts for the drilling and completion techniques we're going to use for the wells.
And what is slide 8?
Slide 8 is a specific survey plat for the well that was proposed. In this case, with that letter was the number 1 well. It just shows the surface location and then the first take point in the formation and then the bottom hole location. With and it shows the vertical extent of the well within the horizon.
And slide 9 is what?
That's the actual first page of the directional plan that was sent to Kerr-McGee, just showing what our intended, at this point in time, the intended path of the wellbore would be.
So this wasn't all the material that was provided you. These are just highlights for this PowerPoint presentation. Is that right?
That's correct, yes.
And did you provide all this information so, in your opinion, Kerr-McGee could give a more detailed analysis as to whether or not they wanted to elect to participate in the wells?
We wanted to make sure Kerr-McGee had enough information that they knew what the planned well was, correct?
Okay. All right, so when did you serve these well participation packets on Kerr-McGee?
The September 21st date.
And each well proposal packet included certain things which were required under Rule 530. What were those?
Well, of course, the description of the location and the objectives for the well, the estimated drilling and completion cost, and the estimated time when we're going to drill the well.
And as of today's date, have you received any information from Kerr-McGee which indicates they desire to elect to participate in the drilling of any of these wells?
We have not.
In fact, you have an understanding that they have declined to participate?
Based on conversations, they had indicated last week that they were probably going to decline to participate in wells.
Thank you. I have no further questions for Mr. Bailey.
Crosser,
Yes, sir. May I?
please.
Thank you, sir. Mr. Bailey, what's your exact working interest in this 320-acre unit?
We're still doing final title work out there, and of course, subject to the pooling. We anticipate we will be in the high 40s range as far as our working interest. Right now, we probably have about 45% working interest.
Okay, 45%. And what would be your net revenue interest in the 320 based upon your estimate or your title work to date?
You know, I don't have that number right in front of me.
What would you estimate it to be?
I think in general, the lease burdens out there are probably going to be 20% on average with some overrides that we have with other parties.
So potentially high 30s for net revenue. Would that be fair?
That'd probably be a fair number.
Okay. And do you have any interest in the northwest quarter where Kerr-McGee has its leasehold and where you intend to put your surface location?
We do not have any interest at this point in time. That's correct.
Okay. And just so I understood your testimony, you plan on drilling all 9 wells in the first quarter of 2016 as your AFEs propose?
The anticipation that we spud in, we do pad drilling, and that's the anticipation at this point in time.
Okay. All right. You testified a little bit about your costs. Tell us, do you have a gas gathering agreement in place?
We don't at this point in time.
Do you intend to flare your gas?
We do not intend to flare the gas. There's a pipeline within probably 200 feet of our location.
Okay, and whose pipeline is that?
It's DCP.
Okay, and what do you anticipate your gathering rate to be?
You know, we have not talked with them yet regarding that.
So you don't know your gathering rate?
That's correct.
Okay. All right, let's talk about oil. Assuming any of these wells produce any condensate, do you have an oil pipeline planned, or are you planning on trucking your oil?
The plan would be to truck the oil out.
All right, well, you testified you're familiar with costs in this area. What would you estimate your trucking cost to be?
You know, I'm not familiar enough with the trucking cost specifically to be able to tell you what those costs would be.
Okay. All right, let's talk about water. What are you going to do with your water produced?
The produced water would be trucked out also.
All right, and do you know your water costs to transport this water?
I do not.
Okay, do you know your disposal cost?
I do not.
Okay. All right, let's talk about surface use payments. Are those annual payments or are they one-time payment?
The surface use payments we would have are one-time payment.
One time, all right. And are they well by well, or is it one fee for all your wells?
I'm going to object to this if I could at this age. You know, this is a pooling application. I don't believe this question has any material impact on whether or not the pooling application should be sustained under the Act.
The pooling of Kerr-McGee in this case is based upon the actual cost to be expended. Obviously, Mr. Bailey has testified he doesn't know the cost for oil gathering. He doesn't know the cost for gas gathering. He's testified he doesn't know the water transport or disposal costs. So in order to pool Kerr-McGee under terms that are fair and reasonable, we need to know what those costs will be. So this is, not only is it relevant, it is the issue, one of the issues before us today.
It makes sense that we'll allow it.
All right, well, all right, so surface use payments, you said, are one-time payment, and are they well by well, or are they for the entire surface use?
I believe they're well by well.
Okay. And do you know what your cost of capital is, sir?
For our company?
Yeah, for these wells. You're proposing to spend $30 million and potentially cost Kerr-McGee to spend twice that as the majority working interest owner, so I just need to know what your cost of capital is if you're going to spend.
That's a mischaracterization. The total is going to be $30 million for these wells, and so there wouldn't be double that for what your client would pay.
Well,
I mean, it would be half of that.
whatever, 30 million, you're asking Kerr-McGee to spend $30 million, so I'd like to know if you have a cost of capital.
No, you're not looking for Kerr-McGee to spend $30 million. We're looking for Kerr-McGee to bear its proportionate share, which is half.
Which at a 200% penalty equals $30 million.
I didn't know you were talking about penalty. You were talking about costs.
Well, you've asked for a penalty. All I need to know is what your cost of capital is.
I guess I don't understand how our cost of capital would even be relevant to the whole discussion.
I'm going to object to that then on grounds of relevancy.
Fine, if you don't know what your cost of capital is, that's fine. No further questions.
No redirect. No redirect.
Okay. Next witness.
Call my next witness, Andy Peterson. Good afternoon, Mr. Peterson. Could you please give your name and state your occupation for the commission?
Andy Peterson, Senior Vice President of Operations for Integrated Petroleum Technologies.
And do you have any experience working projects in the DJ Basin?
As we discussed last month, I have I've been a consulting petroleum engineer in the DJ Basin for over 25 years. I've worked in DJ for over 30 years and been an oil and gas operator for approximately 20 years into DJ.
All right. What I'd like to do is just kind of go through the exhibits, which Mr. Bailey talked about. Are you familiar with these exhibits, starting with slide number 4 and going through exhibit 8? So if I pan these down, this would be the well proposal letter. It would also have attachments, various pages from the attachments for the well proposal letter. Are you familiar with those?
I've seen this letter, yes.
Okay. And have you had a chance to look at that and appreciate what it says?
Yes, sir.
And now I'm going to go to this page. I went too far. This slide 6 is the cap sheet, or the first page of an AFE. Have you seen that before?
Yes, I have.
And this is Mr. Bailey talked about this being for the Vale well number 1 well, but you've seen all the AFEs for all the subsequent wells too, which are part of this package 1 through 9.
Yes, sir.
Okay. And based on you're looking at those AFEs, have you had an opportunity to assess whether or not there are reasonable estimates of costs associated with drilling and completing each well?
The approximate $3 million drill and complete cost appears reasonable to me.
And how do you make that representation that it's reasonable? Have you done any comparables in the area or anything like that?
Yes, sir. My company is involved with a lot of drilling in the area, and the Cub Creek costs are right in the middle of the range of AFEs that we see.
Now, Mr. Wozniak, when he was talking to Mr. Bailey, talked about costs associated with the product which comes out of the well, whether that be water or whether that be gas or whether that be oil. Are you familiar with gathering costs for those products in basin?
Normally, crude purchasers such as Cub Creek would sign a crude purchase agreement with a refiner in Denver or Wyoming, and the purchaser would pick up the oil at the lease out of the tanks in a truck and pay Cub Creek or the operator of the well the posted price less a certain differential. And so the differential, which could be equated to what Mr. Wozniak was talking about as a gathering cost, runs in the $5 to $7.50 per barrel range in this area of the DJ.
Now, there are also costs that would be associated if there was a pipeline in the area for liquid removal.
Correct, and that's something that we need to keep in mind, that we're on the wells Kerr-McGee drills, and I have no firsthand knowledge, but it would be reasonable to expect that the cost of installing the gathering facilities, be they oil, gas, water, that Kerr-McGee as operator would not do that for free to a working interest owner. So there would have to be some form of cost recovery of installing the gathering system. So whether you pay it as a trucking cost to get the oil or the water out, or you pay it as an amortized construction cost for laying a gathering line, again, I have no firsthand knowledge of this, but you'll pay a gathering fee one way or another for every well.
Do you have an opinion as to whether or not those costs, whether they be for pipeline removal of the liquids or for trucking removal of the liquids, are necessary expenses for a well which is produced?
You have to pay something to get the product or the produced water out, correct?
No further questions from Mr. Peterson.
Cross.
Mr. Peterson, good afternoon.
Good afternoon.
I wanted to talk to you a little bit about the cost issue that you addressed. First of all, you heard Mr. Bailey say somewhere in the mid-40s was their working interest, right?
Yes, sir.
And net revenue potentially in the high 30s, percent-wise.
I don't believe he gave a number, but.
Would that seem reasonable to you?
Yes, sir.
Okay. All right, let's talk about expenses. I know last time you said that this was an economic venture. Do you recall what price you used to determine that for gas and for oil?
The Cub Creek economics were run at an initial oil price of $40 per barrel, escalating to, I believe, $54 per barrel. And their gas prices ranged in the $3.50 to $4.50 range.
Okay. And is that the assumptions you made when you determined the economics of this venture?
That's correct. I reviewed Cub Creek's economics and determined that the venture was economic.
All right. And are you familiar with the NYMEX strip price as it is today or this week?
I know that the price of WTI is approximately $44.60 today, and deducting somewhere between $5 and $7.50 puts it in the high 30s or $40 range. I'm not familiar with the strip price exactly, but.
All right. Well, and that's pretty close. If I told you that the 12-month strip price for oil now at NYMEX as of Friday was $44.65, would that seem in the ballpark to you?
Yes, sir.
All right. And then with your $5 to $7 differential, that would mean for oil net at the wellhead somewhere shy of $30 or $40. Is that right?
Somewhere in the $40 range, correct. Right. As I said, high 30s, $40.
All right. For oil, is there any price at which you would recommend to your client not to spend the $28 million?
That's a entirely site-specific analysis, and the Cub Creek economics clearly show that these wells can be drilled at a positive rate of return of approximately 19%. And I reviewed their economics and they look reasonable to me. So I would recommend, based on that and other factors, which are totally up to the operator, that they drill those wells.
All right, well, you used the price beginning at $3.50 for gas, you said?
Yes, sir.
Okay.
No, the Cub Creek economics did, and I reviewed them.
Right, but you testified that it was economic, and then you just said there was a 19% rate of return starting at $3.50, escalating to $4.50.
Yes,
Am I correct?
Correct.
All right. So let's assume, if I told you again that the NYMEX strip price as of last Friday was $2.68 for the next 12 months. So what would that do to your economics?
Nothing, sir. There's a significant bonus or kicker or add-on to the gas prices in this area due to the BTU content.
Oh, okay. So what is your BTU content on these wells?
Such that it results in a $3.50 gas price.
Really? Okay. Well, I'm glad you can get more than everybody else can on NYMEX. What gathering rate did you use to determine that this was economic?
There was no gathering rate. That's the number that Cub Creek used in their economics based on gas being sold, comparable BTU gas being sold from comparable wells in the area.
But sir, you testified that this was an economic venture last time, and I'm just making sure you did not have any deductions for any gathering then.
No, that's cranked into the gas price.
Oh, really? So the gathering is free?
No, it's in that $3.50 number.
So in other words, you're
There's not
getting
a
$4.50, $5.50, and then deducting a gathering charge?
I didn't say that. The wellhead price that Cub Creek used, which is reasonable for wells in this area, is $3.50 initial.
Okay, so are you familiar with the gathering rate in this area as you described it, that would net a $3.50 gas price?
As I said, there is no specific gathering rate. Cub Creek used a $3.50 number, and that includes the price for the product minus gathering, transportation, compression, fuel, and that number is reasonable to me.
Okay, what LOE numbers did you use, lease operating expenses?
In the, I would have to look back. I don't exactly recall.
Okay, and on the water trucking, what water trucking rate did you use?
That was cranked into the overall lease operating expense number, which, as I said, I'd have to look back to refresh my memory. It runs about $2.50 a barrel, trucking and disposal cost included for wells of this kind in this area.
Okay, $2.50, and then what about disposal charges for
That's
the?
included in the $2.50.
So an additional $2.50 for that, okay.
No, sir.
That's not what he said.
No. It costs $2.50 a barrel to truck and dispose of a barrel of water.
And this is from section 12?
Yes, sir.
Okay. All right, and did you utilize, since you weren't sure about the LOEs, did you utilize any surface facility charges to determine your economics?
That's included in the $3 million drill and complete cost. So there's no additional costs that aren't included in the operating cost.
All right. And did you utilize a cost of capital figure when you determined your economics?
That's cranked into the overall rate of return. We assume that there's no interest rate plugged in because Cub Creek doesn't, or Carnegie does not necessarily have to pay any interest on the money. They may have, you don't know where their money is coming from, and neither do I. So we don't plug in an interest rate or a cost of capital.
Well, sir, you testified it was economic. So if you don't know where their capital comes from, that's fine. Let me ask you another question. You just said it was a 19% rate of return. So, and this was based upon, as I understand it, a lot of assumptions as to what these costs would be. At what price for natural gas would you not drill these wells, sir?
I don't have a specific number in mind. Again, totally dependent on well cost and a number of other factors. So there's no hard and fast number that I would give you.
All right, let's change subject for 1 second. you testified that these were, or at least Mr. Bailey said these were approximately a mile long laterals. As the engineering consultant, they're not 5,280 feet with the setbacks, are they?
No, sir.
So what is the approximate distance that these laterals would be in the productive zone?
Approximately 4,200 feet in the productive zone.
All right, 4,200 feet. What if you ran into mechanical difficulties and could only drill that well 2,000 feet? Wouldn't it all produce from Kerr-McGee's leasehold?
I'm going to object to this as relevancy under the pooling application. Again, I mean, I suppose that's always a possibility that there might be some mechanical problems. We'd have to certainly, this area's been spaced now for development. So development's going to be pulled out of the unit area, whether it comes from Kerr-McGee minerals or Cub Creek minerals. They're all one and the same for purposes of spacing.
I'm just asking if the lateral was a short lateral, would it produce 100% from Kerr-McGee's minerals?
If only the first half of the lateral were drilled, yes, sir, it would only produce from Kerr-McGee's minerals.
All right, and you mentioned you consult for other people. Let me just ask you, you wouldn't recommend that someone in a perfect world locate their facilities on someone else and drill their minerals without their consent, would you?
It's actually speculative. It's not.
Well, hypothetically.
You don't have to answer that if you don't want to.
I think you might be confusing the surface issues versus the downhole, but no, I couldn't answer that.
So you wouldn't produce someone else's minerals?
Objection. Relevancy.
Well, you're asking to pool 100% interest into your drilling and spacing unit. I'm simply asking if you would recommend to your client that you drilled 100% on another party's interest.
I believe that gets into legal areas that I am not qualified to express an opinion upon.
What about vertical wells? Did you evaluate the economics of a vertical well on the northeast quarter where you own a working interest?
Not specifically, sir. No, not for this hearing.
How about directional wells?
Again, no.
How about short lateral horizontal wells?
No, sir.
All right, no further questions.
Redirect.
No redirect.
Next witness.
You know, I don't have any other witnesses, but I'd like the commission to take administrative notice. That's right. And I'm sorry, administrative notice of its consent agenda today, and all those applications which are comprised that consent agenda. And with that said, I'd rest my case for Cub Creek.
I'd object to any administrative notice of all consent agendas. I don't even know what he's talking about.
I'm confused. I don't know what that means, but.
You know, the consent agenda consists of a variety of applications which you've reviewed in anticipation of presenting or of having those matters supported on the consent agenda today. I just request, which I have the right to under the rules, that you take administrative notice of your consent agenda.
Well, if you would do that, you have to recognize that none of those parties objected.
Yeah, I think the commission has broad discretion to accept anything for administrative notice, but all evidence must be offered for some sort of purpose. So unless you define for what purpose, I would say we shouldn't.
What the purpose would be is to once again just demonstrate to the commission the number of pooling applications were considered on today's docket, and which includes pooling applications brought by Kerr-McGee, which requests the recovery of costs and statutory penalties associated with those. That's my only purpose. So it's more of a statistical thing.
I think it's something Mr. Willis can address in his closing, but for purposes of the record of this case, it's already in a bundle in front of you, and that's what you should focus on.
Thank you. Okay, we are then with Kerr-McGee offering some additional witnesses.
And if we could go ahead and grab the mouse from
Yes.
Mr. Willis, thank you. And maybe get a time check from Ms. Murphy. Thank you. All right. All right. Good afternoon, commissioners. Again, Jill Fulcher on behalf of Kerr-McGee. We're going to begin with Ms. Kaufman. Ms. Kaufman, please state your name and your position with Kerr-McGee.
Shay Kaufman. I am a land supervisor for the Kerr-McGee non-ops group in the Wattenberg.
And how many years have you worked as a landman for Kerr-McGee?
Approximately 8.
And as your time as a landman, have you been involved with spacing and pooling lands in Colorado?
Yes.
And does that experience include spacing and pooling requests under the statute and under Rule 318A?
Yes.
So has Kerr-McGee proposed horizontal wells that would be drilled through and produce another owner's minerals?
Yes.
And has Kerr-McGee ever received an objection to its plan to drill through another owner's minerals?
We have.
So what is Kerr-McGee's response in those circumstances?
In those circumstances, we work with the objecting party to come to mutual terms to drill the well that would allow us to drill the well. Otherwise, we would work with the technical team for alternative drilling practices or plans.
So in those circumstances, has Kerr-McGee ever drilled through and produced a tract where the owner has expressly said no?
We have not.
Now, did Cub Creek originally propose these wells under Rule 318 Large A?
They did.
And did Kerr-McGee receive written notice of Cub Creek's proposals under Rule 318 Large A?
We did.
And what was Kerr-McGee's response to these proposals under the GWA rule?
We objected.
Can you tell us the basis for the objection?
The well bores were passing through our leasehold estate.
And what was Cub Creek's response to Kerr-McGee's objection?
They did not pursue a hearing on those, and they in turn spaced the north half.
Going back to the application lands before us today, can you remind the commissioners the legal location of both Kerr-McGee's and Cub Creek's respective leasehold in the application lands?
For North 68 West, Section 12, we have the northwest, and Cub Creek has the northeast.
And will the wells subject to today's hearing be drilled through and produce leasehold entirely owned by Kerr-McGee?
Yes, they will.
And has Kerr-McGee provided its consent for Cub Creek to drill through and produce its leasehold?
No.
So if the situation were reversed and Cub Creek did not authorize Kerr-McGee to drill through the northeast quarter of its leasehold, what would be Kerr-McGee's response?
Again, we would work with the party to come to mutually agreeable terms for drilling through those lands, or otherwise we would change our drilling plan to avoid them.
Thank you, Ms. Kaufman. No further questions?
Cross. TikTok.
Let me just ask you this, Ms. Kaufman. I just have a couple of questions for you. With regards to Kerr-McGee using the statutes for pooling authority in Colorado, does Kerr-McGee ever use that authority?
We do.
Okay, and so you use that also to recover cost drilling as well as statutory penalties. Is that true?
Yes.
But it's your testimony that you don't do that in cases where somebody basically objects to drilling through their minerals.
That's correct.
But if they're part of the unit area and you're going to be draining their minerals, do you still have that same objection? Or do you still give them that same grace? If you're not going to be drilling through their minerals, yet they're going to be located in the unit area.
The pooled unit?
Yes, and they object to that. Will you refrain from pooling their interests, or will you proceed with pooling their interests?
If there was an objection, and I'm trying to think of an instance where, that has not occurred, but we would work in every possible way to negotiate something with that party to be able to drill those with their consent.
But if you're going to be draining their minerals but not drilling through them, and you're not able to reach an accord with them with regards to their participation or leasing minerals to you if they're unleased, you would obviously, in my opinion at least, and I think it's your opinion too based on your testimony, you would bring a pooling application against them, and you would seek cost recovery as well as risk penalty.
Objection. I think this is a bit hypothetical and getting a bit far afield from from what Ms. Kaufman testified to in her direct.
I think she testified, and I'm just looking for clarity here, because she's indicating through her testimony that if you're drilling through her minerals, Kerr-McGee has a policy, business practice, where they're not going to proceed against pooling against your interests. However, if your minerals are being drained and you're not being drilled through, I'm just asking her a question as to whether or not she would basically, capture those minerals through cost recovery and penalty under the pooling statute.
Somewhat hypothetical, I guess.
It would, if you wanted to ask it in a hypothetical sense, I would. But I mean, it's just a question is what their practice is.
I think by its own question, you kind of answered the difference between her testimony, right, and your hypothetical. I mean, Ms. Kaufman testified about a well bore going through a tract.
She did.
Right.
She did. And I'm just wondering, I just asked her a question, if it doesn't go through, if the well bore doesn't go through those uncontrolled interests, whether or not you would continue to pool those interests for purposes of seeking cost recovery and risk penalty.
If you,
I'm gonna, it's gonna be my judgment. She doesn't have to answer that. It's just too far.
Okay.
Okay.
You don't have to answer that.
Okay.
You want to volunteer and answer, go right ahead.
No, yeah, no.
I've no further cross.
Are you allowed to? Well, yeah, I mean, you're allowed to do anything you want, yeah.
Now I'm worried that now I'm going to be like Mr. King, that I don't think direction very well. Commissioner King. Yeah.
Anything that will shed light on this is a good thing.
And I didn't know if Commissioner Spillman had a question, so this definitely gets out of my area of understanding. This is, that your question is kind of went up here somewhere. So I'll try to put it down to my level. So I heard you testify that if Cub Creek objected, then you would work with them to reach an agreement so that you could pool the minerals. And I know it's in there are a number of applications for pooling today. So what I'm left with is that if you can't reach an agreement, then you just don't drill the wells or don't go forward with the pooling, or what do you do?
We would pursue an alternative plan.
And what would that be in this case? Give me an example.
You could, I suppose, shorten your laterals, or, drill the other way. But we've pursued this before. We've never had, or we haven't, that to my knowledge, had a situation where we could not come to an agreement with the objecting party.
So in all the properties that you've pooled here in the DJ, you never had a non-consent? Never had someone non-consent to drilling?
We've had non-consent. Yes, that's happened. But as far as objecting to passing through a mineral estate, we've always been able to come to terms with our other parties.
So you could, which is, I agree, it's different. You could pool it. You still agree to the pooling, but then you might have a non-consenting party?
Sure. Yes, absolutely.
Okay.
Non-consent, I mean, it can be based on non-consent because of cost or something like that.
Yeah, that'd be outside of pooling, be within the joint operating agreement or something along that line.
Yes.
Okay. So, but the party would say, well, I'll agree to pooling, but I'm not going to consent to have
correct and take the penalty.
Participate in the wells. I'll take my penalty and move on.
Yes.
Okay.
Director Spielman, did you have a question?
Thank you, Mr. Chairman. No, I didn't, but thanks, Commissioner Benton. And in fact, Mr. Chairman, with apologies, the press of other business kept me from returning at the onset of this hearing, having missed 25 or 30 minutes of opening and direct testimony. As I see it, I will not be able to participate in the vote, so I won't ask any questions.
Well, I would certainly give you permission to ask questions if you thought the answers would help the rest of us who will be.
Fair enough. Thank you. If the vote happens today, though, I won't be able to participate.
Understood.
Thank you.
Okay, ma'am.
Yeah, Chairman Compton, maybe just one question on redirect based on Mr. Willis's questions. Ms. Kaufman, in your experience and in Kerr-McGee's practice, is there a difference, or I assume, is there a difference between non-consenting as to costs and non-consenting as to drilling?
Yes.
All right, hopefully that helps a little bit. If it doesn't, we'll continue to talk about it, but I think that's the.
No.
Okay.
It doesn't help.
I suppose,
Can you
yes,
elaborate
there's-
a little bit here, please?
Oh, sure, go ahead.
There's non-consenting as to the cost of a well is one thing that's very different from non-consenting as to the way a well is drilled, or, a well bore going through your minerals and producing from your mineral estate.
And which I'm struggling to understand. Sorry, I'm struggling to understand that difference, because I don't get to, if I agree to the pooling, you'll have to help me out here. If I agree to the pooling and then go non-consent on the well, there's a penalty that I will pay for recovery of costs before I get to participate in the well.
Mhm.
In which case my minerals are pooled. If I disagree with the pooling in the first place and it gets pooled, there's also a cost recovery.
Mhm.
The cost recovery is the same. I'm going to get the same reward out of that well. So, I see your attorney shaking, one of your attorneys saying, no, that won't work. So that's why I'm confused.
So of course, I'm very, very confused if you're confused. If I select a non-consent based upon cost, and I'm willing to pay the penalty, I'm going to pay something, but it's going to be, maybe I'm guessing, lower than what it would cost me to actually participate.
Not necessarily.
No.
Usually it's going to be higher.
You're penalized until payout, correct? So
I think his director may be able to clarify this one.
Please.
This may or may not help. If you go non-consent, if you choose not to participate and are pooled, in Colorado, you get a 1/8 royalty. So you get revenue from the first drop of production as a royalty owner, and you pay nothing out of your pocket. Your 200% is paid out of proceeds.
Mhm.
So the main difference is I'm not writing you checks. You're taking what I owe you for your 2X out of production if there is any. So there's no risk. Now, there are things that have been said that I do not understand, like the difference between non-consenting drilling and non-consenting pooling. I don't know what that means.
Well, I guess I asked the question, I can rephrase it. Is there, in your mind, a difference between permitting another operator to drill through leasehold that Kerr-McGee has taken the time to obtain for itself and going non-consent on AFE costs?
yeah, I mean, those are two different things. Going non-consent based on cost is different than going non-consent based on an operator's wellbore going through your estate when you don't want it to, correct?
For whatever reason.
For whatever reason.
You just don't want to for whatever reason.
Whether it's that, we believe that there's a better drilling practice, or,
And that's fair and reasonable. So maybe a different direction, a different way you choose to develop that. But yet, I think the value may be the same. If it's, you're going to non-consent, say the first 4 wells or something like that, or the first 4 wells get pooled. It raised another question on the northwest quarter, since you're the land person testifying as expert. In the northwest quarter, what is that part of the UP strip? Do you own 100% of the minerals?
No.
You not. So it's leased from someone else?
Yes.
Okay. So what's your net revenue interest?
It is a little bit over 74%.
Over 74%. So you get 100% working interest, 74% NRI.
Correct.
Okay.
Okay. You have another witness.
We do. All right, joining me now is Mr. Schnabel. Mr. Schnabel, please state your name and your position with Kerr-McGee.
David Reed Schnabel. I'm a petroleum reservoir engineer with Kerr-McGee, working business development in the Wattenberg Basin.
Thank you, Mr. Schnabel. We're going to move right over to Exhibit 1. If you could go ahead and walk the commissioners through this exhibit, please.
So direct your attention to the upper left-hand corner. That is the plan of development as proposed by Cub Creek, pooling in their northeast quarter and Kerr-McGee's northwest quarter in the north half of Section 12 for North 68. Now, evaluating the economics of this, if you look to the lower right-hand corner of the slide, you will see we ran an analysis using the type curve data supplied by Cub Creek, capital numbers supplied by Cub Creek. We used NYMEX strip pricing. We had to make a few assumptions with regard to timing and the OpEx and transportation costs. With respect to timing, we were assuming these would turn to production sometime in the middle of 2016, which seems to be consistent with what we heard before. OpEx and transportation, we assumed costs that were close to what Kerr-McGee experiences with our own operated wells. Now, based on that, the wells as proposed by Cub Creek do not make economic thresholds for Kerr-McGee. In fact, they come out at a rate of return of 0 at a NPV 10%. And that's demonstrated by the red square in the upper right-hand corner of the slide.
All right, thank you. And you stated the OpEx and transportation costs were estimated based on Kerr-McGee's cost to operate. Are Kerr-McGee's OpEx and transportation costs indicative of other operators in the DJ Basin?
They are not. Kerr-McGee's costs are best in class in the basin. And then based on what we see from other operators based on their investor relations material, and then also from the non-op exposure that we experience with other operators, our costs are far and away much better than any other operator in the basin.
And you heard Mr. Peterson estimate, I believe, that the water and trucking and disposal costs were around $2.50 a barrel. In your experience, is that accurate?
I can't fully comment on that because we do most of our own disposal and trucking. So I have not analyzed third-party trucking and disposal. However, for the oil trucking and delivery, that his cost of $7 a barrel seems to be about light by about 50%. We've experienced upwards of $10 and even $15 a barrel, another non-op exposure that Kerr-McGee has in the basin per barrel of oil trucked.
All right, so let's go ahead and go back to Exhibit 1. Could you please explain to the commissioners the significance of the blue cell that we see on the top right side of the exhibit?
And so on the top right side, that is a alternative proposed plan of development from Kerr-McGee using drilling long laterals across Section 11 and Section 12 of 4 North 68 as displayed in the lower left-hand corner of the slide. We ran the economic evaluation again. We did assume that the production would be a 2x multiple and then the capital would be a 2x multiple just because we're doubling the length of the lateral. And that improves the NRI for Kerr-McGee by quite a bit, and that does make this an economic endeavor for Kerr-McGee.
And in your experience, is it possible to evaluate the economics of a project without knowing specifics regarding transportation costs, gathering costs, OpEx costs?
No, because there's too much that's left to assumption. When we have had to make those assumptions in the past with other non-op exposure, more often than not, those costs come in, the actuals come in much higher than our assumptions were.
So based on your review of Cub Creek's materials, are these proposed wells economic?
As the wells are proposed, no, they're not economic.
And in your opinion, will these subject wells ever reach payout times 2?
No, they would not.
Finally, in your opinion, will Kerr-McGee recover or receive its just and equitable share of its minerals in the Northwest Quarter?
No, we would not.
Thank you, Mr. Schnabel.
Cross.
Mr. Schnabel, I just have a couple of questions for you. You indicated on your direct examination with Ms. Fulcher that you ran economics for the benefit of Kerr-McGee. Is that true?
That's correct.
But you don't know what the economic scenario is for Cub Creek as they propose these wells?
No, I do not.
Okay. And so the fact that they may not make your threshold could be different from the threshold which has been demonstrated by Cub Creek.
It could be, but I have to evaluate these with the fiduciary responsibility to the shareholders
I
of
understand that.
Anadarko.
I understand that. Okay. Okay. And so if they don't make economics for you, I assume you would perhaps not want to lay out your capital and participate in the drilling of the well, even though an operator who's proposing those wells may have economics that are met by it.
Correct.
All right. Thank you. Nothing further.
Redirect.
I have no other questions for Mr. Schnabel.
Thank you, Mr. Schnabel.
Thank you.
Maybe we have a commissioner might want to ask a question.
Sorry. First question, it said, when I look at that graph in the upper right, I see it says performance based on improved NRI. So what's your NRI in section 11 then? Because you have a pretty low one in the northwest quarter of 12.
In 11, that's 100%.
So you own 100% of the minerals?
We own that section, yes.
When you looked at this, because I think that Cub Creek testified that notionally theirs is about an 80% NRI, which is a little better than 74%. I mean, that's not a huge difference, but did you rerun your economics on their NRI just to see what that would do?
For that scenario, we ran it on the actual NRI would be across the well bores.
Okay.
For the alternative scenario.
For the alternative, I'm
Yeah.
talking about if you just look at what Cub Creek's going to do across section 12, if you ran your economics on an 80% NRI as opposed to 74%.
We did not, because that's not how it would hit our books.
So you're just, if you were faced with this decision, if this wasn't pooled, we weren't talking about pooling, if you had to make this decision today, based on the economics, would you go non-consent on the wells?
Yes.
So notionally, it's just don't want to participate because it's not economic.
That and it's development across our minerals that we don't agree with.
And so that's what I'm trying to get to is why do you not agree with the development across your minerals? Is it just based on economics?
Well, across our minerals, Anadarko, we would realize operational efficiency, I guess. It comes from drilling, well over 1,000 wells in the basin right now. So we would improve the economics for both parties by leveraging that.
Okay.
So that's all economics.
So it's still based on potentially improving the economics. And I don't know if you're the right person to ask this or at some point, because there's been a lot of discussion around gathering for gas out here and the fees charged for that. And how did you address that in your economics?
We ran that at both, I believe, the West gathering fee for service and then DCP's gathering as well, because this area could go to either West or DCP.
And notionally, what are their fees on a per MCF basis?
West is, I believe, it's around 70 cents per MCF or MMBTU.
70 cents an MMBTU?
MMBTU.
And they're both DCP and West roughly about
DCP, I believe, does not have a carry fee or a takeaway fee, but they keep liquids and book them as reserves.
So they do a POP?
Yep, percent proceeds.
Percent proceeds, okay. I may have some others, but I need to make notes, sorry.
That's wonderful. I think you've run out of witnesses.
That's correct.
Okay, Ms. Murphy, as I understood, Commissioner.
So if Cub didn't get what they have proposed today, is Kerr-McGee proposing to come in and pool north half of 11 and north half of 12?
You ask that again?
If Cub didn't get what they have proposed, are you guys going to come in and pull north half of 11 and 12?
That could be possible at some point. We're constantly examining our development fields or scenarios all across the field. So this is an area that is being looked at for development.
So it wouldn't happen in the near future?
I can't comment as to a time frame, but it is being looked at.
So you guys own the northwest of 12, right?
Correct.
And Cub owns the northeast, which is under a subdivision? So you couldn't drill from there anyway? So it's annexed. It's in the city limits.
It is.
Okay. Thank you very much. According to the sheet of paper that's generously provided to me by Ms. Bach, we could have a presentation of staff analysis if the commission requested that. And if I were going to bet money, I'd bet money the commission would like to have that information. I mean, you offered.
Yes.
Okay.
And you're going to need that mouse as well. You have a little.
Jill. Oh, I'm sorry. Oh, you need that? I'm sorry. Stu.
Memorize this. You should see that.
This is Stuart Ellsworth with the Oil and Gas Conservation Commission. Kind of just going to run through sort of some just kind of basics, more of a summary, at least in part, pointing out that as you probably are aware, Kerr-McGee has 50% of the total 320 acres. My understanding is they have the full ownership of that half of this discussion, and Cub Creek has a majority interest in the eastern half of the 320. And then what we're discussing is the pooling of all interest in these 320 acres, and the discussion about the pooling is the cost recovery, and that's based on state statute. And then the next point is that what we're in the commission, as far as what is defined within our role, is that just and reasonable evaluation of the cost recovery. And then the next point is...
Excuse me, Stuart, if
Yes.
you don't mind, would you just go back one slide? Just give me 30 seconds.
Oh, sure. Sorry.
Thank you very much.
And so let me just add to that slide that the basis by which is the AFE that's been presented to us. That's our ability to understand what the cost of this project is. And then the cost that's been presented to us on that AFE is $3 million. And in the rule that's defined by which we can judge at 530 B2, it says the cost to drill and complete the well. So that's what the AFE is presenting to us. And that's the basis. We get these AFEs on all of these poolings. And so that's how we have to judge. We're a state agency. We don't go drill wells. So our basis is what a sort of a general summation of reasonableness of what was presented to us. And that's what we've evaluated. And this is comparable to what other operators have presented to us. I guess if I were to editorialize, which I probably shouldn't, what we're talking about is some of these second items are operational costs. It's hard for us to justify what one company's operational cost as compared to another. And 530 says drilling and completion cost. And so based on that, in general, what's presented to us as far as this pooling and the FE cost seems within reason of what we have seen in the past. And we recommend approval. Thank you.
Okay, thank you. Any questions for staff? Okay, thank you very much. Okay, we are at a Cub Creek rebuttal, if there's any time remaining. And of course, Ms. Murphy will let us know.
There is. You have about 26 minutes left, and Kermicki, you have about 17.
I don't have any rebuttal case.
Okay, closing statements, Cub Creek.
Thank you. I think it's important, commissioners, that as you deliberate this matter, that you recognize that we're not here on a spacing application. We're not here for density approval of space lands. This is a unit area which you established at the last hearing in September to 320 acres for the north half. And now we're here under the pooling application for an assessment as to whether or not we've complied with the relevant portions of the Act and the rules of COGCC with regards to how we test whether or not individuals that are interest owners, where there's not been a voluntary agreement to pool interests, whether or not they want to exercise their rights to either participate or lease. Now, we don't have to worry about the leasing here because this is an operator who is sophisticated. Obviously, it's Kermicki. They operate hundreds of wells within the basin. And so what we need to do, Cub Creek needs to do, and what we did do in this particular case was 35 days prior to today's hearing, we provided certain materials to them. And those materials are basically just set out by the rule again. And that is an election letter. Do you want to participate in this? Do you want to bear your costs? If Kermicki has concerns for what those costs are, they can look to the attached materials which we provided them, which included the AFE, which is the authority for expenditure for each one of these 9 wells. And that specified what a viable estimate was for the drilling and completion of each one of these wells is. By virtue of them not electing to participate, they now are subjecting themselves to cost recovery as well as risk penalties, which are afforded by the Oil and Gas Act, and it's specified in the Oil and Gas Act. So that's the test that we're here for today, to see whether or not we've complied with that, whether or not those AFEs are reasonable. We've heard the staff say that they are. They're certainly on par with other operators that are putting projects like this together in the basin. And so it's just important, again, I can't stress this enough, to not go down the rabbit hole of the Kermicki is baiting you with right now. And that rabbit hole is to open up, it appears to open up whether or not these lands should be developed with mile-long laterals or 2-mile-long laterals, because that's already been decided. We had that hearing in Gunnison to address that issue. And so, I appreciate your attention here today. I think your questions have been very, very probative. I apologize for confusing that whole issue when I asked the one question, but I certainly appreciate the commissioner's questions, which appeared to clean that up. And that was the issue with regards to drilling through somebody's minerals and producing from those minerals. In my opinion, I mean, we've set out the boundaries of the unit area right now. We're going to drill wells through that area. We're under a duty and obligation to pay proceeds based on direction from the commission with regards to the pooling statutes, which is what we're requesting here today. And that's our post. We're going to be draining minerals from Kermicki. We're going to be paying according to the directives of statute. And if they choose not to participate and appreciate, our risk in putting up the capital for it, then they'll be penalized for that. And that's basically what the statute allows us to do. So this isn't unusual at all in any way or step. I'm going to end this show. It was a great show. Let's see if I can go over to.
It won't make Jimmy Kimmel.
All right. Oh, look at this. It's in a good spot for me. So,
I actually think it may.
Maybe the whole kit and caboodle, perhaps.
So, I was just looking at your consent agenda for today. There are 99 applications which were presented. 74 of those applications touched on pooling. And of that 74, 23 were Kerr-McGee pooling applications. Each one of those pooling applications requested the pooling of all interests and made requests for recovery of costs and risk penalties. You approved those on the consent agenda today. And so Kerr-McGee has followed what they're supposed to do under the Oil and Gas Act and the rules to get those orders from the commission. And that's basically all that Cub Creek has done today too. We've tested the water from Kerr-McGee as to whether or not they wanted to participate. They indicated they didn't want to participate. It didn't meet their economics. It meets our economics. It meets Cub Creek's economics. And we talked about that at the last hearing in Gunnison. We even talked about it a little bit more today. But we're ready to go on this project. We've got APDs which have been approved and issued. We've got an oil and gas location assessment which has been approved. And so, we're good to go on this. And we're just requesting, this final step of securing your authority to secure those rights which we have available to us under the Oil and Gas Act. I don't have any further comments. Thank you.
Closing statements, Kerr-McGee.
Thank you, Mr. Chairman. Thank you, members of the commission. As you can tell, we have two main thrusts of our position today. And the first one, before I get to the trespass issue that I'll try to clarify if I can, is just simply under the statute. There's two parts to the statute. They're very clear. Number one, the terms that they've proposed have to be just and reasonable. And number two, they have to be able to proceed without unnecessary expense. I would argue that the economics of this project are uncertain at best. Spot prices are way underneath the price that was used to determine economics. Testimony showed that we have no idea what the gathering rate will be for gas. We have no idea what the disposal rate for water will be. We have no idea what the trucking for water will be. We have some speculation of $7 and up to $7.50 to transport oil. The $3.50 that was used by Cub escalating to $4.50. The spot price is $2.68 for the next 12 months. So economically, this is not just and reasonable. These wells were testified to for Kerr-McGee would never pay out and have a negative rate of return. So the first issue that I think you need to decide is under a pooling agreement, are these terms just and reasonable? Should Kerr-McGee pay 100% of its share of the cost as the majority working interest owner when we know, or at least the evidence couldn't prove that these were just and reasonable? The other thing I want to point out and just everyone remember is that Cub Creek has the burden of proof. They're the applicant here. They must prove that this is just and reasonable and that they can do it without unnecessary expense. That's not a burden that's on a protestant. That is on the applicant. So that's number one. Number two, and our concern about the trespass. Let me explain Kerr-McGee's position. First of all, and I'll try to address this to Mr. Benton. Let's just assume that one of your neighbors on the western slope says to Black Hills, we're going to come on your property and we're going to put our surface location on your property. We're going to drill 9 wells on your property and we're going to produce those 9 wells. Yeah, you own most of it, but I think we're going to go ahead and produce it because we're going to do whatever we want on your property. Maybe we'll do a shorter lateral. So maybe 100% of the minerals will come out of you. But you know what? We're only going to pay you half of that. And you know what else? We're going to take control of your mineral interests because you got the lease. I know you went out and bought it, but we think we can do it better. So we really don't care what you want to do on these properties. We don't care if you want to do a longer lateral. We don't care if you think you have a bigger plan. Because frankly, we're going to let the Oil and Gas Commission trump your rights as a private property owner. Because we think, heck, we're WPX, we drilled more wells than you. I think we can do it better. Or we're Marilex, or we're someone else. We'd like to come on your property, and we'd like to do that. And so Oil and Gas Commission, tell us you can do that. Now, we're not talking about a situation where we're on our own property and we drill up to you. We're not talking about a situation where we would come to you and say, we would like to pull you in here, and you say, you know what? Heck, with 200% penalty, we'll do that. But I would submit that of those 23 pooling applications that are before you today, there wasn't one other party that said, wait a minute, you're coming on my property and you're trespassing. So let's go back to what we're talking about here. There's only one horizontal well rule that you have drafted, as Commissioner King always mentions, and it is Rule 318 capital A. Okay, and under Rule 318 capital A, which was originally proposed in this matter, what happens? You take each 40 along your wellbore, right? And you give everyone else notice that owns that 40. And what happens if one of you that own that 40 objects? As this Assistant Attorney General Matter said last time, you can object and in essence stop that well. Why? Because the commission recognized that that is trespass when it promulgated Rule 318A. Okay, now that person can come to a hearing and that person can argue all they want that the well ought to go through, and then you make a decision. But just think of the innocuousness now. If one well Kerr-McGee was entitled to object to and could prevent that well from being drilled, but let's switch this and call it a drilling and spacing unit. Now you can drill 9 wells and we don't have the right to object on that basis. That can't be the right.
I need to interrupt you. I don't think that's the staff's interpretation. I think the veto right applies to the initial offer stage. It's not an enduring veto that obviates the need for a commission hearing.
Right, but as you mentioned last time, Assistant Attorney General, that does give the party the right to protest. It gives the right to a hearing, and in that hearing, the issue of balancing whether that well ought to be drilled or not is this decision of this body. And the reason that that objection lies is because of the trespass argument. So for example, if I own 8 of 8 40s in a row and you own 1, I can argue, no, I don't want that well to be drilled, and this commission would have to decide that. All we're asking here is we have the right to a hearing and we have the right to argue that that is a trespass. Now, let's talk about trespass. Go ahead.
I have another question for you too. Sorry for keep interrupting, but it is about trespass. And I think really the issue before the commission is whether this is a proper exercise of the police power rather than adjudicating whether it results in a trespass or not. And both of those issues are addressed in the Continental versus Farrar case, which I don't think is in your brief. And do you think that case applies here or should be applied, or is it wrong, or can you give us your thoughts on that case?
Be happy to address that. First of all, I want to address 2 cases. One is the Texas Supreme Court case in Garza that everybody is familiar with. Garza, that's Coastal versus Garza, and that's the case where the court was very clear, the Texas Supreme Court, that drilling next to someone else's leasehold and that you happen to frack into where potentially across a lease line molecules would go was not a trespass. However, the Supreme Court in Texas did say if you locate on the neighbor's property and you actually bottom hole, your hole actually goes and produces from them, that would be a trespass. I think the Continental versus Farrar case is distinguishable. And let us tell you what that is. First of all, that's North Dakota. So that's a different rule. So I'm going to admit that we have different issues. But in Farrar, what happened is one operator owned the northwest quarter and the southeast quarter. And it was determined that the only economic well that could be drilled by the NDIC decided was a horizontal well from the northwest to the southeast. Okay? By definition, unless you can go perfectly down that center line and hit the middle, you're going to go either one side or another and go through someone else's minerals. So Farrar objected and said, wait a minute, that little piece might go through me. And what the North Dakota court said is, wait a minute, yeah, technically that might be a trespass, but since that's the only place that we could drill the well and the only way that it was economic, we're going to go ahead and let it go. And they specifically said, and by the way, trespass really wasn't briefed before us. So if you read that case carefully, I'd say, sure, I can sit there and say North Dakota has said one thing, Texas has said another. The reason this is so important is we do not have that jurisprudence. So the real issue that the Attorney General brings up for the state of Colorado is, does our Oil and Gas Commission Act trump or abrogate common law trespass? In other words, does trespass go away under police power? So in other words, could we say to Commissioner Benton, you know what, we really don't care that you want to control your operations. Someone else can do it. Maybe they'll do it better. Maybe they'll do it worse. Maybe you want to put a well pad on your own property and drill the other direction. Well, you can't do that now for safety purposes. So there's a lot of issues here, and maybe we're going to need a judicial determination, and maybe this is the case that will decide it. But the bottom line for us is sanctioning a trespass is not authorized under the Oil and Gas Commission Act. Because remember when I started this, what it says is if you have a pooled unit, we're going to deem, this is the statute says, we're going to deem the production goes on the non-consenting owner's tract, and we're going to deem the conduct took place there. It doesn't say, which the legislature could easily have said, hey, listen, when you form a pooled unit, whoever the applicant is, they can put the well wherever they want. And now let's back up. I know not all of you were here in the early 80s, but in the early 80s, we came before you, this commission, many times on the Codell Niobrara. And what I would ask for in those matters was an 80-acre drilling and spacing unit, right? Many times, our applicant would only own 140, the other applicant would own the other 40. And every single one of those orders said, fine, you can have a drilling and spacing unit, you get one well. Every single one of those, one well was drilled on the party that had the right to drill. You never went over to the other party and located a well on their property without their permission. And if you look at every one of those issues in front of us, the implied consent when you object to a pooling is only objecting to the cost recovery. If any one of those people in that 23 applications had said, hey, wait a minute, I don't want you drilling through on a horizontal basis my well and producing my minerals, then as we heard testimony from Ms. Kaufman today, Kerr-McGee would have stopped and said, great, we're not going to drill through you of your objection. So there's a big difference between, in my view, trespassing, taking someone else's minerals without their consent, versus penalizing someone with a risk penalty to say, listen, you can go ahead and drill it and I'll take my 200%, because most JOAs that people propose are 300% or 400%. So oftentimes you sit there and say, fine, in today's economic price, we want to risk, you spend the risk capital, I'll take my 200%. But again, our statute does not abrogate common law trespass. In order to do that, it must be specific. The legislature is smart. They can draft a statute to make it clear. But as we know, our statutes as they're set were from 1954 forward, and not that many changes in the statute. There are some in your rules, but not that many in the statute, so they don't necessarily fit perfectly in the horizontal world. So the traditional rule that if your well drifts and lands on someone else's property, that's a trespass. Okay? So now that's what the cases all say, the bottom hole, to answer Commissioner Benton's issue, but that's because that's where it was producing from. I would submit that a horizontal well produces all along the completed interval. So it's the same issue. And there's something that Commissioner Hawkins may remember in his prior life, but there was a well that was drilled in front of this commission in a 320-acre unit in coal bed methane area in La Plata County. Well drifted. And unfortunately, it landed on the Southern Ute Indian tribe side of the drilling and spacing unit, at which time that entity was successful in getting that well immediately shut in by this commission. Why? Because the well trespassed without permission and bottom-holed somewhere else. So I would submit that some of the testimony last month, Commissioner Holton, when I know you were on the phone, it was hard to hear, was there were locations and potential locations in the city of Johnstown. And our view is to penalize Kerr-McGee because Cub Creek went out after the fact when there was partial subdivisions there in the city of Johnstown and made a determination, listen, I don't want to deal with Johnstown. I don't want to deal with those people. I don't want to have to deal with the beauty shop and everything else out there. So I'll go locate my wells on Kerr-McGee. That shouldn't be rewarded with a penalty in our view. So again, the definition of just and reasonable is very broad. And so from our point of view, it's not just and reasonable to pool Kerr-McGee into an uneconomic well. And so you don't even have to reach the trespass argument if you choose not to. But if you do risk it or do reach it, I would also submit to you that simply allowing someone to come on your property, drill those wells, and penalizing us is not just and reasonable. That's all I have right now.
Rebuttal.
I just have a very brief rebuttal. Thank you for that, Mr. Chairman. And that's, once again, if I could just shift the focus back to why we're here today. It's a pooling application that's been brought by Cub Creek. Yes, and we have the authority to drill 9 wells within there. We've proposed 9 wells. And when I look at things, this whole spacing exercise that Mr. Wozniak keeps on alluding to was decided the last go round. You approved the application, the spacing application. You authorized the 9 wells based on our showing at that particular hearing that those were economic. That was an economic enterprise and how these lands should be developed. So all this other noise about mineral trespass, it shouldn't conflict what the commission's going to do right now today in their deliberation, because their deliberation should be based on what's afforded by operators when they bring pooling applications under the rules. And that's, whether or not, they want to bear their expenses to develop this area with Cub Creek. Obviously, they don't want to do that for whatever reason. It doesn't make economics, whatever. But that's the test that's been taken on by this commission time and time again as they approve pooling applications brought by a variety of operators. Like I pointed out, 23 applications brought by Kerr-McGee, more than that by the old operator community. Some 10 different operators have done the same thing today, and the commission has exercised its authority in approving those applications. We're just, we've followed your rules. We've come with this pooling application and requested the relief which is contained within the application, and I think that's regulatory certainty, which has worked for decades under the rule of this commission. And so we're just, we're trusting the same thing. Thank you.
Thank you very much. If you give me just, go right ahead, and I'm going to.
You want
to? No, go ahead. I'm not worried about it. Go right ahead.
Okay. And nice job on the example there. I appreciate that.
It's a real life.
Well, that's one of the risks that you take for being an operator in the state as well. I'm interested. You said 23 pooling applications. No one objected, and I think your land expert testified about 8 years of experience here. So I'm left with, in all those 8 years and all of these applications, Kerr-McGee, or Anadarko as the case may be, has never had someone object to being pooled. Which, it's not really forced pooling. Essentially, you've never had to force pool someone into a pooling application in that 8 years, ever.
Okay, we have had.
You get on the mic.
Yeah.
We have had very few objections, and we have been able to work with. They've never come here. We've been able to work with other parties to come to a resolution, and it's always ended up that. Well, I can't say always, but the examples that I know of, we've worked with them, and we've been able to drill the wells together with their consent.
And if they wouldn't have agreed, you wouldn't have come here and asked us to do what Cub is asking us to do?
If they would not have agreed, we would have come up with an alternative.
Mr. Hawkins.
Yes. I think, and I don't want to start deliberating too much right now until we're ready, but since we've got the slide in front of us, all of these pooling applications that were on the consent agenda were just that. They were on the consent agenda. There were no objections. And I think that if you're a party to a pooling application, you have the right to object. You have the right to ask all of the economic and development questions, and you have the right to explore whether or not there's going to be trespass or not. I'm not an attorney and I can't answer questions about trespass, but I do have experience with oil and gas development, and I feel like it's, I don't have an issue with somebody coming to the commission and saying, we object to this pooling and here's why. So just because there were a bunch of pooling applications on the consent agenda doesn't really impact my decision on this pooling application at all. And I feel like, this is something that we're going to have to deal with. I think the spacing application did establish what kind of potential ownership each of the parties might have in wells, but I don't think it addresses all of the issues that go along with pooling, and that is it economic? Are the terms fair and reasonable? Is there unnecessary expense, etc.? So I think those are the issues that we have to decide today.
And that leads me to a question, unless you had one.
No, sir.
Okay. And then,
Hundreds of questions, but I think
well, I probably don't have nearly the questions or the level of intelligence, the ones that you'll ask, I guess. So this is, and it may actually be something for the AG, because I'm trying to get sort of my head around what's at issue, and part of what, as Commissioner Hawkins said. So what I hear is that if Kerr-McGee objected to the pooling on the basis that they don't believe it to be economic project. And I would say specifically it's not economic for Kerr-McGee. Cub Creek says it's economic for us. By objecting, then when Kerr-McGee objects to this and they say we're not going to participate in the pooling, to me that sets up the trespass issue. And because they're going to object to that, so they're not participating, so now there's a mineral trespass. So my question to us is can you elaborate a little bit on what Mr. Wozniak has brought forth on, if we go forward, how does that weave into that trespass issue? Because to me, the trespass is a consequence of not agreeing to go on with the wells. If Kerr-McGee had agreed to pool, then to me there wouldn't be any issue with citing the surface location where it's going to be sited.
While Mr. Matter is contemplating that, may I ask you all if we could excuse these folks and go ahead and close the testimony? We'll continue to deliberate, but we don't need any more input from them. Is that okay? Or
I think I had perhaps one more question.
Mr. Matter, we will not forget.
That was it. I know. The only question was related to the experience in more or less forced pooling.
But so a couple of questions.
Should we move there?
Sure, I would just assume go ahead and close. Don't close the record?
I would prefer if we could just leave it open.
Okay.
Just in case what Mr. Matters says raises another question, because I actually was going to ask Mr. Willis if he would care to comment on the trespass issue, since it certainly affects their development, and I don't know if that's fair to ask him that.
I think you could ask him whatever you want. Let me make a couple comments. The reason I thought taking administrative notice of what's on the screen right now and we've been talking about is it's a different factual scenario. And I understand Kerr-McGee's argument that speak now or forever hold your peace. And if you don't speak, you're deemed to have implicitly consented to a wellbore being drilled through your wholly owned minerals. So I think this slide, it shows that you process a great deal of applications every month and that many of them relate to pooling, but I don't think it really speaks to the issue. I don't think trespass speaks to the issue either. Again, when Mr. Wozniak and I were both speaking, the issue for me was is this a proper exercise of your police power or not? And that's the question. Knowing that Kerr-McGee owns 1/2 of that unit, is it fair to pool Kerr-McGee into this unit over their objection? And you're not litigating the issue of whether it's a trespass or not, because if and when we have a court decide that issue, it will first address, in my view, the question of police power. And that's what this Continental versus Farrar case talks about. In your opinion, are these facts, do they meet the requisite criteria of the pooling statute, which is largely a fairness and equitable determination?
And if they do, by definition, we have eliminated potential for a trespass.
That's what North Dakota would say, that the legislature, when it granted the commission the pooling authority, it abrogated the law of trespass. I tend to disagree with Mr. Wozniak a little bit, to the extent that, yes, we're in different states, but both states arise out of the Model Act. And the key piece of the Continental versus Farrar decision was that the drilling of a well anywhere within the unit is deemed the proper conduct of oil and gas operations anywhere on the unit, and the parties share and share alike under the pooling order.
Let me ask you a follow-up. There's some question as to how far down the line we go in determining the economics of this operation. Mr. Willis has argued that it's limited to a couple of factors. Mr. Wozniak is arguing down to water management on the site.
I think the truth is somewhere in between. It's not a full-blown audit, and it's not a rubber stamp. And I know that Commissioner Benton has given that a great deal of thought, and Commissioner Hawkins have, and others too. And that's why those business people are on this commission, to sort out those sorts of details.
Okay, Commissioner Benton, you still had a question out here.
Yes. That helps a lot. It says essentially that the trespass issue is separate from, we make the decision based on, is it just and reasonable, and are there any unnecessary expense? So I do struggle with some of that, and I'll bring that up in the deliberation. So if you could speak to the trespass.
I very much analyze it just like Mr. Matter did. There is this Farrar case. I'm familiar with it. It talks about state police power. That's the big thing that I pull out of that case. I think the commission, in its decades of working through the Oil and Gas Act, has and presenting rules underneath the Oil and Gas Act, has manifested its police power, basically. And what I'm talking about is, we come to the commission, we space lands. What does that mean? We can get regulatory authority then from the commission, from the director, to get APDs, because the lease lines basically are affected by the spacing unit. And so we've taken the next step now to pool all interests for development and operation of the unit. So I think, just like Mr. Matter indicated, I think in Colorado, in all practice and purpose under the Oil and Gas Act, common law mineral trespass is affected by your rules, which are attendant to prevention of waste and protection of correlative rights. That's how all those rules were adopted and approved. So I think I'm pretty much in lockstep with Mr. Matter with regards to what occurs with regards to development in Colorado. I think mineral trespass is affected, I think, as early on as the approval of the spacing application and the spacing unit, the designated spacing unit.
Okay. I think Mr. Wozniak said he sees that Continental versus Farrar as being somewhat of an isolated case. Is that correct? Because it was sort of the only way that well could be drilled. That's what I heard you say.
And it was the only case I could find that goes the other way than we're arguing. I just had two quick comments. One of those is on Mr. Matter's position about you could go either way on those downstream costs. My question is, are they going to be subject to the penalty? And I have a feeling that every bit of that is subject to a 200% penalty if your order is granted. So to me, there may be some uncertainty, but if they're going to charge us for gas gathering, you're going to charge Kerr-McGee for oil gathering and oil transport, and double those charges, they certainly are. part of that. If they're willing to go on the record and say, no, you won't bear that share, that's a different issue, but they're not. With respect to that trespass, I still think what we have to go back to our statute where it deems production to go on another property. It doesn't say that you can locate the well anywhere that you want on somebody else's property. And my example of a short lateral is not unusual. That does happen fairly often. And in that case, all of these molecules, every bit of the production would come from Kerr-McGee. And you have to decide whether that's fair and reasonable. But I think you can make this decision based solely on whether this can be done without unnecessary costs, and you don't even have to reach the trespass decision. Or you can reach that trespass decision. We're not asking for damages. We're not asking for any of the things you'd ask for in court. We're just simply saying there's never been a case before this commission where you have authorized trespass on someone else's minerals over their objection.
Okay. Gentlemen, we're going to close the record without objection. Record closed. Thank you very much. Deliberation. Not that you haven't been deliberating a tiny bit beforehand, but now's the time. Now's the official time. And by the way, Commissioner Spielman, I fully recognize your decision to not vote in the final vote. But at the same time, if you have insight that would be beneficial, I will hope you might contribute that.
Thank you, Mr. Chairman.
Okay, give me some thoughts. I'm operating on the assumption, Mr. Matter, that we are bound by the Colorado Oil and Gas Act and the regulations established by this commission. At least those are our sideboards.
That's correct.
We do have some room for interpretation, however.
That's correct, too.
Some comments.
Would you, I'm sorry.
No, that's all right. I'm going to go
I was
ahead.
just going to ask if you thought it would be advantageous, would be helpful to frame the exact issue this commission is going to address, according to the
Sure.
and regulations.
Sure. Should you pull these minerals over Kerr-McGee's objection is the discrete question. And that's really bound by section 116.6 of the Act. It speaks to pooling orders. Each such pooling order shall be made after notice and hearing and shall be upon terms and conditions that are just and reasonable and that afford to the owner of each tract or interest in the drilling unit the opportunity to recover or receive without unnecessary expense his just and equitable share.
That's kind of like when I
And
asked you.
Stuart had that up actually earlier.
Yeah, we read that earlier. That's like when I ask you, what can we do here? And you say anything you want. Okay, gentlemen, Commissioner Benton, you were.
Yeah, a couple of comments that just sort of, that I've struggled with on this that came out during the testimony, and I'm still a little concerned about the trespass concern, even though you said if we pull it, it sort of becomes a secondary issue. When you think about just and reasonable here, by just having the space pooled on the 320s, Kerr-McGee is at an economic disadvantage because they have a lower net revenue interest. So then that means is it just and reasonable to subject them to the drilling and completion of this well when the revenue that they'll receive will be less on average. I mean, it gets pooled in, but it sort of drags everything down, and that makes it less economic than if you drilled on a longer section. So that, I'm not sure if that factors into this or not. So I do have a concern over that. And then the unnecessary expense, yeah, you're going to have to truck it as opposed to pipe it away. But it was brought up earlier is by Mr. Peterson when he testified is that the pipelines are going to get their pound of flesh too. And a lot of times their cost of capital is a lot higher than a drilling company. So they may build that into the fees that they charge. So we don't know that. So I don't have an answer as to which way I'm going to go on this yet, so I'm going to wait to hear what other people have to say.
Okay.
Over there either way.
Commissioner Hawkins?
I'm just going to put in that from what I heard on the record, I was really disturbed that the applicant couldn't really describe what the operating costs were going to be. They didn't really show us any economics other than say it's a 19% rate of return. To me, that's not really a demonstration that they have an economic project, or that they've given the Kerr-McGee their the information that says this is going to be an economic project. I am concerned that if we approve the pooling, that there is a deficiency in the fair and reasonable terms and unnecessary expenses based on the testimony that I had today. So that would be my biggest concern. I really can't address the trespass issue. I do understand that once we've spaced it, it kind of establishes a boundary for determining ownership and where the wells are going to be located inside that spacing unit. And I think the trespass is an issue that maybe we need to explore or understand better. But for me, I don't even really have to go there. And I have a difficulty approving the pooling application over the protest of Kerr-McGee in this case.
I would add a comment to that, though. Keep in mind that if Kerr-McGee doesn't agree and it gets pooled, then Cub Creek they're sole risking the well. So they believe in it enough to say, I think it's economic enough that I'm willing to spend 100% of the dollars to go drill and complete these wells. So I believe in the economic. So they're taking on all the economic risk up front.
Well, I mean, I understand that, but they also, if your 50% owner doesn't pay anything and you get their 200% of their costs, your economics might look a lot more attractive. I don't know.
Mr. Chairman, and once again, we find ourselves, second guessing business models and trying to make decisions. And I think even the industry folks would understand that if they were actually making these decisions, they would have far more information than we have in front of us, and probably far more information than we as regulators need or should have. That's the inherent difficulty about where we find ourselves. I guess I pull back a little bit and say, this analysis that the applicant is obligated to come forward with is, a demonstration that they're not incurring unnecessary expenses. There's an inherent incentive for them not to incur those unnecessary expenses, and nothing I've heard from Kerr-McGee makes me believe that there are unnecessary expenses. There are expenses that are going to be incurred. I'm not sure they would be any different for Kerr-McGee than they would for Cub Creek right now. So my feeling is, and there is that penalty, that risk assessment, but the operator, Cub Creek, has no ability to know or determine whether Kerr-McGee which option they will choose. And so they're going forward knowing that there's two ways to go, and either one of them they're going forward. So again, I guess my feeling is I'm comfortable with staff's recommendation, and my inclination would be to grant the request.
Mr. Howard?
Thank you, Mr. Chair. I'm trying to contemplate the state of oil and gas development in Colorado if we allow a party to reject forced pooling. I can think of any number of owners who would like to throw a spanner in the works by rejecting a pooling order from this commission. So I really think there are a lot of situations out there in which we get a long list on an application of all the mineral owners that are being noticed. And if just one of them can stop a pooling order, we'd have chaos. Maybe that's desirable, I don't know. But I think we'd be crossing a line that we're not too keen on being on the other side of.
I'll ask, perhaps the director may remember this, or our AG, but I believe we had one before where we had a drilling spacing unit and pooling, in which, and the only difference being in that case was that the company that was going to pool the other one, they were going to start on their own surface. They were essentially pooling, and the other party objected to that pooling, and we went ahead and approved it anyway.
I think you approved the spacing and denied the pooling. I'm thinking of Conoco Renegade.
I was thinking of the Condor and Prima one. Back a little further back.
I can't remember, I'm sorry.
Me neither, sorry. I thought, younger mind might remember.
Other comments or deliberation?
I'm happy to call the question and make a motion that we accept staff's recommendation as presented.
A motion has been made to accept staff's recommendation and approve this pooling order.
Second.
And a second. Any further discussion? Hearing none, all those in favor indicate by saying aye.
Aye.
Opposed, same sign.
Aye.
Nay. Aye.
Okay, there were 2 nays or 2 ayes that were in the negative. Is that right? Did I miss any? I heard 2. Then that means that the application stands approved. All right, thank you.
Thank you, Mr. Chair.
Total for the record, 5-2.
And by the way, I'd just like to comment,
Two abstentions.
Ms. Bach, I'm very, very much appreciative of this wonderful sheet of paper that you gave me. That's very, very helpful. Oh, well, maybe perhaps I should reserve judgment. Okay, I'm going to go ahead and continue on unless some of you older guys need a break.
So to answer, on the surface ownership, I asked that last time, they do not own the surface. And they have a surface use agreement with the surface owner to develop.
Well,
Right.
his whole argument on our surface.
You went to the, clear about that.
Mr. Chair, 5 minutes? We're on next, so can we maybe take a 5-minute break?
Let me consult with counsel. Oh, wait, you're counsel.
That's right.
We're going to take a 5-minute break.
So first of all,